this petition become infructuous in view of the fact that in the meantime, my lord, the term of the societies are, my lord, over.
Mr. Jeremy Chaudhary, the legal counsel appearing on behalf of the petitioner, submits with the term of the society having been over, the instant with petition has become infructuous. Taking into account the above, the instant with petition stands closed in paying out of the instant petition.
Considering item number second, I appear for a respondent, but the petitioner says lordship may not be able to decline to take up the matter, my lord.
Okay. This will be for any other thing.
Lordship, I'd like to mention item number 24. Mr. R.D. met with an accident.
What has happened?
He met with an accident.
You do it. 2019
Lordship,
matter.
I'm not in the case, Lordship. I'm just mentioning on behalf of him.
We'll see when the matter is 2019 matter.
But he is in under doctor observation, Lordship.
Let's see. I won't dismiss it. You be there. If I can allow it in your presence, it's okay. I won't dismiss it. Then I don't think you will have a problem. If I allow your petition, then you don't have a problem. If I have to dismiss it, I won't dismiss it. I'll grant an adjournment. Okay.
Thanks.
May I please, Your Lordship, with the consent of other side, item number 30, I beg to mention item number for adjournment.
Why?
As my senior is out of station.
No. 2022 matter, 4 years down the line.
Kindly fixed any other date on the next week.
Okay, cost of 10,000 it is. Yes,
Any short
see
date.
when the matter is. Next.
May it please your lordship. So in item 35, we have filed an affidavit in reply. Lordship may kindly allow to bring it on record. If you oblige.
My lord, I beg to mention petition number 5331 2025. Come upon admission column.
Well, mention it before court now, whichever court it is, not me.
Okay.
May it lordship, I'd like to mention item number 28. The lordship may not like to take up the matter.
Why?
Let it senior counsel, Mr. Ashok Sharma, is going to parents.
This did before any other bench, taking into account that Dr. Akesara, senior counsel, will be appearing in the matter.
May it please your lordship, item number 19. Today's list has become infructuous.
Huh?
Infructuous.
Infructuous. Why?
Is related to election matter.
What election?
Board of director to GPSS, Gramin Panchayat, Samabay Samiti.
We'll see when the matter reaches, okay? We make that mention then.
In this case, lordship, I have been informed, lordship. The party is not interested to continue the proceeding, lordship. It can be allowed to be improved.
Mr. M.H. Ahmed, the legal counsel appearing on behalf of the petitioner, submits that the petitioners are not interested in to pursue with the instant proceedings. Accordingly, the instant petition therefore stands closed on withdrawal. Interim orders, if any, stands ready.
But we put it like,
Transfer appeal to approve.
of like.
May I please, Your Lordship? Lordship, kindly give 2 weeks time for filing the amendment petition.
You require how much time for filing that? It has taken more than a year. Absolutely no. What is the matter about?
Petition, some community welfare,
What is the matter, Mr. Gogoi?
Lordship, here they are challenging the construction of a community welfare scheme, Your Lordship, on the petitioner's land, Your Lordship. They are saying they have already filed bid petition. Thereafter, the Honorable High Court directed to consider representation. Until unless that request is not considered, no construction will be carried on. Now, the condition is that since the representation is not yet been disclosed yet, the construction works have been carried out, Your Lordship. That's the main.
Now, have you considered his representation or not?
That representation, and first and foremost, PHE
Where is
is
the
not part in
direction
the earlier
part?
litigation.
Huh?
PHE was not a part in the earlier litigation. PHE was not a party in the earlier litigation.
Now,
Now they are, but thing is that make Lordship. May kindly come to page 33. The revenue department has to consider, Lordship.
hmm,
The revenue, page 36, Lordship.
what is the direction passed by this one?
The order is asked from at page 33. Operative parts are page 35, last one.
Yes, revenue. What is your stand? What is your stand? There was a categorical direction. That in such consideration is given by the commissioner in further construction of any part of land of 59 because 2 cutters covered by DAG or cutter number shall not be proceeded with. Then, what is your instructions on this? What is your instruction? No, why haven't you disposed of the representation, the commissioner and secretary? And how the construction could be carried out without this concern? Get your instructions next week, Monday. Yeah. In the meantime, you file whatever it is required by tomorrow. The present petition has been filed alleging that in spite of specific direction passed by this court dated 8/3/2017 in WPC number 1341/2017, whereby there was a direction to the commissioner and come secretary to the government of Assam in the revenue department to give due consideration to the representation dated 4/1/2017 and to pass a reason order until such time such consideration is made by passing a speaking order. No construction should be carried out in over any part of the land measuring 59 bighas 2 kathas covered by DAG numbers 20/21/24/26/29/69/71 /253/75/76/101 of Pata number 10 of Revenue Village, Hazongbori, Panbari Moja, Kamrup. It is the specific allegation in the instant writ petition that in spite of such directions, the representation have not been considered on one hand by the revenue department, and on the other hand, the concerned respondent authorities are carrying out construction. Pusta. Notice was issued in the instant proceedings as far back as on 16/6/2023, but till date, the Revenue Department have not placed on record as to whether the representation dated 4/1/2017 submitted by the petitioner have been considered. Taking into account the above, list this matter again on 20/07/2026, on which date Ms. So-and-so, who appears on behalf of the Revenue and Disaster Management Department, shall obtain instructions as to whether the representation dated 4/1/2017 have been considered or not, and if so, the reason therefore. So it is observed that if no instructions are placed on the next date, this court shall be constrained to call the concerned official, be constrained to seek the personal appearance of the concerned official of the Revenue Department. In the meantime, the petitioner is directed to file the fresh memo of parties before the registry of this court within 3 days.
May I please, Your Lordship? Lordship, there was an amendment in this petition, which I have filed on 16/6/2026.
The amended cause title, you have filed it.
Lordship.
The amended cause title having been filed, has the notice been issued upon a new year?
No, Lordship.
Having pleaded the Karbi Anglong Autonomous as respondent, accordingly the same is it. You are appearing for the year. Have you filed your affidavit?
We have already filed affidavit.
So
and
we
it
can
be
have it
disposed of.
for disposal for admission
And already also, my lord, it can be disposed of. It can-
now?
My lord,
Okay.
my lord, as a, under Article 244, my lord, government has already constituted, my lord, commission to determine the boundary dispute between the different districts and the different states, my lord. According to the petitioner contention is that they are not under the jurisdiction of Karbi Anglong Autonomous Council, they are the jurisdiction of the Huzai district. So yeah, they should go to
Huzai?
the, then it should go to the
District
commission, my lord.
Huzai.
My lord, yes, it should go to the commission. We have filed the, my lord, notification, my lord. That is in page 85, my lord.
Let's see what is the prayer of the petitioner. We have to give effect set aside and positive notices issued by the Karbi Anglong Autonomous Department. No, now the question is, they say that they do not fall within the ambit of the Karbi Anglong Autonomous Council. And therefore they cannot be imposed with any such tax. Now, have you arrived at any finding of fact to the effect by the Karbi Anglong Autonomous Council?
We have, our contention is that our official visited the place and they are within the territorial jurisdiction of Karbi Anglong Autonomous Council.
Then,
Whether they are within the territorial jurisdiction of Huzai district or Karbi Anglong Autonomous Council, it can be decided that particular area, my lord, boundary, it can be decided by the commission. If your lordship look
now
into the,
understood, Mr. Sutya, the problem lies there. The moment you say that,
Right.
you cannot impose it. The moment you are saying that this has to be now decided by the commission,
Right.
thereby we cannot permit you to impose it.
yes, sir, that point is there, ma'am. Yes,
So therefore,
my lord, if I say like.
if you make that submission, it becomes
Then-
you take
then
this
it should
matter
be-
outside your hands.
But in the similar cases, my lord, in other courts dispose of it like that way.
But
directed
but the
the
problem
petitioner
lies
to
that
the
I can very well send him to the commission, but
Right.
if he doesn't go to the commission, then
Then we cannot. Let's fix it down the date, my lord. Right.
but there you have to come up with
Yeah.
these facts.
That regarding.
Now,
If your lordship looking at the page 85, my lord, or affidavit, my lord. Lordship, look.
page
Page 85. That is a government notification.
okay. As per the memorandum I signed between the cartoon to the common and admission to identify constituent This commission is made under what provision?
My lord, the article, under my lord, paragraph 14(1) and my lord, article 244 also, my lord. Your lordship look into.
But this is a permanent commission.
My lord, now, my lord, government, has not permanent commission, my lord, under article 244, my lord.
Two.
44A, my lord. 244
No,
is
this is
applicable.
the formation of an autonomous state comprising of several certain tribal areas in the Islam and Islam.
Article, my lord, Schedule 6, my lord. Schedule 6, paragraph 3, my lord. It is considered under article 44, my lord. 6 schedule, paragraph 1, my lord. 3, my lord.
Yes, what is this?
The governor may by public notification include any area,
Schedule 6, paragraph,
paragraph 3, my lord.
power of the district council.
No, my lord, autonomous districts and autonomous region, my lord. 6 schedule.
Schedule 6.
But we're looking to.
Autonomous, Schedule 6, yeah, I object to you, man. Provisions of administration of Schedule 6.
My lord.
Then,
Provisions as well as
made by
administration
public
of tribal
notification.
areas.
It is paragraph 1(3).
Paragraph 1.
1(3).
1(3).
Not 3. This is what.
Paragraph
1(3). The
1(3).
governor may by public notification include any area, exclude area, and create an autonomous.
Creating increase in the area of any autonomous district, diminish the area of any autonomous districts, define the boundaries of any autonomous district. Provided that no order shall be made by the governor under
So
clause.
therefore, the question is,
Now, my lord, lordship.
you are not certain.
My lord, now, my lord, all the, my lord.
Have you referred this dispute
My lord.
as to whether this area falls
Now, we are
before
not
the
referring
commission?
the dispute, my lord. We have, my lord, the boundary has already been defined under, my lord, statutory notification in 1951, my lord. We have annexed it, my lord. If the petitioner claims that they are not within the territorial jurisdiction of by virtue of that particular notification of 1953, then they should go to the commission, my lord.
How do you say so?
My lord, we have annexed it, my lord, that particular notification, my lord.
No. How issue public notice to invite claims and objections from stakeholder?
Well.
Whole consultation, evaluate the demands, so and so commission consider all the claims and objections, submit recommendation to the. Now, this commission reference is being made under what provision?
16(4), my lord.
Of
16(4) of the, my lord, 6 schedule, my lord.
16(4).
Oh, 14(1), my lord, sorry, my lord, 14(1).
Governor may at any time appoint a commission to examine and report on any matter specified to him relating to the administration of so and so, so and so, so and so. Or may appoint him to inquire into and report from time to time the administration of the ministry. But this is different. This is not done.
My
What
lord,
can you
C,
do on the
D, E,
14
and
one?
F. My
Hmm?
lord, C, D, E, and F, my lord.
See,
C, made us specified in clause C, D, E, and F of subparagraph 3 of paragraph 1. So it is, my lord, inclusion and exclusion of the, my lord, area of the autonomous district council. C, D, E, and F. D is increase in the area. E is the diminish the area of any autonomous district.
Sir, I don't think three C, D, E, and F will encapsulate the issue out here.
If the petitioner claimed that they are not within the territorial jurisdiction as per the notification issued in the 1951, my lord, and if they claim that they are under the Pujai district, my lord, they should approach the my lord commission to determine that particular area is within the Pujai district or in the autonomous council.
The problem lies, Mr. Chutria,
And the
because of,
And
you
we can,
see, this, the commission is constituted with the following terms of reference.
my lord,
Issue public notice to invite claims and objections from stakeholders.
Right.
So that is a public notice.
my lord,
And the commission shall consider all claims and objections and submit its recommendation to the government at the earliest.
Right.
Meaning thereby, if we start this process, it will have the effect of a permanent commission. That is why I put the you through. If you give it to an effect of a permanent commission, that every time somebody says somewhere that, okay, I'm outside, you will again go to the commission, it will have a far-reaching consequences.
my lord, my lord. How is it possible?
It's easier for me to pass an order that let him approach there and till that don't take any action. But don't you think that this will give an effect?
My lord,
What does it encapsulate? Here it says that look here, in respect to these under 14.1 CDE and Act, which is there. The governor, the commissioner shall issue notice to everybody, and those people may submit the claims and objection against that notice
my lord,
and consider. Now, if we bring it that in every matter somebody questions the jurisdiction, then he has to go to the commission. Means you are giving an effect that it is an authority to that effect, that it will be a permanent commission for all times to come. It is not what.
not my lord, it's not like this.
So
Now,
therefore,
my lord,
anybody may tomorrow say,
factually, my lord, this notification is issued on the basis of the claims of the Meghalaya and my lord West Karbi Anglong.
yes,
Lord, that there is a
Because of
dispute
that.
in that area. Because of that, my lord, this notification.
because
was
you
issued
have a problem with Karbi Anglong has a boundary dispute
with
with
the Nagaland and my lord,
Nagaland.
Nagaland and Meghalaya. my lord.
Nagaland, there is a boundary dispute. Karbi Anglong may have a boundary dispute with Meghalaya.
Meghalaya.
Because of that,
My lord,
this must have been done.
my lord, without my lord,
But every time anybody may say, sir, is residing in Diffu also, he may come up and say, then look, yeah, I'm outside the Karbi Anglong.
Fine.
Then are you going to refer it to the commission?
no, my-
So therefore, what is his prayer? His prayer is, look here, I am outside, I am in Hosai district. So therefore, you have no jurisdiction to
that
impose.
merit also, on that merit also, petitioner has not submitted any document specifying that he is in the district of the Pujai district, not in the Karbi Anglong, my lord.
Lord.
On merit is also there, my lord.
I think that is a better option.
Lord, my lord,
Instead of going into
My-
this line.
my lord, in the
May I
second,
please, your lordship? Lordship, may I kindly peruse my writ petition, annexure 3, page 22.
let's pay dispose of today also, my lord, any other day.
1 minute.
Yes.
Lordship, continue. This is the voter list which I have submitted, Lordship, that which goes on to prove that we have voted in Nagaon. Our residence and our business establishment are together. So these are the voter
No,
lists.
no, where's your trade license?
Lordship, can you come to annexure 3?
No,
Page
where's your
50.
trade license? My question is, where's your trade license? Annexure,
That's not
page?
annexure 3, page 5. We are paying tax also to the panchayat for doing the business in Nagaon.
No, my question is, where's your trade license?
That has not been annexed, your lordship.
Then they are imposing you the tax on the basis of wage, you must be having a trade license.
Lordship.
Has any or other authority issued a trade license to you? Then matter ends there. Why should we refer it to a commission? Don't you think, Mr. Sutria?
Yes, sir, yes, sir.
His basic idea is that you are asking him to pay
To pay
some
the
tax
tax.
on this particular amount.
My lord,
Under the Karbi Anglong Trading of Non-Tribals Regulation, Section 3, you are asking some them
my lord,
demanding
also
tax
to pay
from
the
them.
tax, my lord.
Yes. Come to the notice that you are carrying out the year without obtaining trading license from the Karbi Anglong. So you must be obtaining some permission from somebody. You cannot carry out trade anywhere
Lordship.
without a trade license.
Lordship, that's correct.
Then where's your trade license? We have it on next week.
Lordship.
Get your information on that.
Lordship.
File an additional affidavit, where is your trade license?
Lordship.
Now, if the trade license is being given by the Hojai Development Authority or something to that effect, it's a different thing. Or any other Gaon Panchayat under the Hojai. Then the matter ends out there. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so, the learned senior counsel assisted by so-and-so appears on behalf of the Karbi Anglong Autonomous Council. The petitioners, how many petitioners?
Your
The
Lordship.
petitioners herein
6.
are aggrieved by notices issued to the petitioners by the Superintendent of Taxes, Karbi Anglong Autonomous Council, alleging violation of Section 3 of the Karbi Anglong District Bracket Trading by Non-Tribals Bracket Close Regulations 1953. It is the case of the petitioner that the petitioner's place of business is outside the Karbi Anglong Autonomous Council. And as such, the said notices which have been impugned in the instant proceedings are without jurisdiction. First, this court have duly perused the materials on record and could not find as to under what authority the petitioners are carrying on business in the present, carrying on the business of trade. Mr. So-and-so, who appears on behalf of the petitioner, submits that an additional affidavit would be filed by the petitioner, bringing on record the trade license so issued to carry on the business in their respective business. List this matter again on 3rd of August 2026 for admission. In the meantime, the additional affidavit be filed on or before 31st of July 2026.
Please, your Lordship. Lordship, I'm appearing on behalf of P. Mohanta, Lordship. Lordship, this is a contempt matter arising out of an interim order dated 16/12.
Any order?
Yes, Lordship. Passed in writ petition number 4970/2020, Lordship. Lordship, the contempt may kindly be taken up with the connected writ petition on some other date, Lordship.
This is contempt. What is that order?
Well, Lordship, the order is in page number 13 of the contempt petition.
Responded. Now they have demolished.
Yes, Lordship. Lordship, the
Then we can, then it's possible dwelling house of the.
Lordship, the boundary gate, cultivated kitchen garden and banana plantation has been demolished, Lordship. And within the ambit of dwelling house, all this falls within it, Lordship.
Joint survey report is there. Anyway, we do one thing. We finish up this matter along with the other.
Otherwise, I am representing the deputy commissioner and Kalal. Both are not commissioner, both close to representative. Both are incoming, both are incoming the subscribers. That's why I'm not able to file application.
It's okay, no problem.
I will press the instruction they produce.
Please do. For a proper adjudication of the instant proceeding, it is the instant proceeding. No. The present application has been filed alleging willful and deliberate violation to the order dated 16/12/2020, passed in deputation number 4970/2020. The order dated. The said petition it is being informed at the bar that the said petition is presently pending. Was taking into account the above, this contempt application along with deputation number 4970/2020 on 17th of August 2026. So you are appearing for contempt? Yes, what is this?
May the Lordship kindly possible for pending.
What?
My senior has come.
Direction be on the page number 36. To consider their representation. Is speaking order of the past.
Direction is to dispose of the representation.
That is done. That is done. Kindly take order dated 27/12. Take suppose fourth page.
Okay, order.
Yes, 27/12. This is the office.
Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Dina appears on behalf of the respondent number 1. The present application has been filed alleging willful and deliberate violation to the order dated 22/10/2024, passed in WPC number
1690 of 2020.
1690/2023, whereby there was a direction passed by the learned bench of this court to dispose of the representation dated 29/12/2022. In accordance with law, within a period of 2 months from the date of receipt of the certified copy of the said order. Pusto. In the case of the petitioner, that in spite of the such a direction, the representation of the petitioner was not, of the petitioners was not disposed of, for which the incident application has been filed. Mr. Dina, the learned counsel appearing on behalf of the respondent number 1, has placed before this court an order dated 27/12/2024, whereby the representation submitted by the petitioner have been disposed of. The said order dated 27/12/2024 being relevant is reproduced, is kept on record and marked with the letter X. A copy of the said order be furnished to Ms. So-and-so who represents the petitioner. Taking into account the above, nothing further remains in the instant contempt proceedings, for which the contempt proceeding stands dropped. That it is further observed that before parting with the record, this court, however, observes that the dropping of the instant contempt application shall not prejudice the petitioner, prejudice or preclude the petitioner to challenge the order dated 27/12/2024, if so advised. We give a copy. Yes, what is this?
Here, Lordship has directed us to take a decision on their application for settlement of land. In fact, with the FPLC, it is placed, I have received the instructions saying the 10 days time, I'll file.
What is the direction? Considering the exercise of the ARCL
108,
period of 6 months will be reasonable to enable the state to complete the trial. We will take agency the entire fact finding exercise for the eligibility on the entitlement of the principles for land development will be considered in the expeditious process before the in order to facilitate the fact finding, right, we are directed to environment. With an application filed alleging willful and deliberate violation to the order dated 23/1/2023, passed in WPC number
62.
579. Huh?
Yes, ma'am.
579/2020. Whereby there was a direction issued upon the state respondents to complete the fact-finding inquiry as regards the entitlement of the petitioner. within a period of 6 months, preferably within a period of 6 months from the date the certified copy of the said order was furnished upon the respondent number.
Page 105. And 106.
On the circle officer come instant settlement officer. Mr. Dina, who appears on behalf of the respondent, number one submits that the respondent number one would like to file a response to the instant application. And accordingly seeks 10 days time to do so. List this matter on 24th of August 2026. In the meantime, the affidavit be filed on or before 12th of August 2026. Liberty given to the petitioner to file reply. Acknowledgement. Yes, what is this?
My lord, will come to page number 16. The order starts from page number 14. Page number 16, my lord, will see that these were the facts culminating into the direction to pay my
Police.
police was involved only to the
Who's
extent
to pay the money?
money is to be paid by the medical superintendent of Silchar Medical College Hospital.
Huh?
Silchar Medical College Hospital.
Okay, they have to pay.
They have to pay. Now, their they cited the impediment in their affidavit file in the writ petition that there were two police cases involving anomalies.
Yes.
Where I'm appearing for contender number 4, Lordship. During his time, Lordship, he had made several communication as per the court's direction to get the records. Now, he has retired, Lordship. Now, the current incumbent has informed me. If the petitioner can show the previous bills, then they don't need to verify from the police records. Because the records are still in the custody of the cops, police officers also. So, if my learned friend, if the previous bills, he can produce and give it to the government. I have just telephonic
To
the current superintendent, Lordship. of
who is
Silchar.
he?
He's not been made a party, Lordship. The previous incumbent was a party in this.
So there is a change of incumbent.
Yes.
Yes, during the pendency of the contempt.
We have made repeated communication to
Mr. H. Liha, the learned counsel who represents the superintendent, learned counsel, the learned counsel for the Health and Family Welfare Department submits that on account of the bills being not provided by the police authorities.
yes, Lordship, the police authorities have the records. If the petitioner has the bills.
No, the police have not provided you the bill.
No.
Comma. The superintendent Silchar Medical College and Hospital is not in a position to carry out the necessary verifications. If further submitted upon instructions that if the petitioner submits the duplicate copies of the bills duly verified by the duplicate copies of the bills, comma. The superintendent, Silchar Medical College and Hospital would be able to carry out the necessary verification for onward payment to the petitioner. Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is not adverse to submitting the duplicate copies of the bills retained with him to the superintendent Silchar Medical College and Hospital Silchar, who's taking into account the above, list this matter on 11th of September 2026 for an update. In the meantime, the petitioner shall take steps for submission of the duplicate copies of the bills in reference to bills in respect to supply of dietary articles required for the hospital amounting to rupees 41,96,374.96 before the superintendent, Silchar Medical College and Hospital on or before 27th of July 2026. The superintendent, Silchar Medical College and Hospital, Silchar, shall thereupon carry out the necessary verification and provide an update on the next date fixed. It is made clear that upon carrying out the necessary verification, the pendency in the instant proceedings shall not, it is further made clear that the pendency of the instant proceedings shall not bar the respondent authorities to make the payment to the petitioner if upon verification it is found that the petitioner is entitled to the amount so claimed or any such amount.
Deeply.
Yes, what is this?
My lord, the operative portion of the judgment is at page 17, my lord. Yeah. Well, Lordship directed the district commissioner to assess the rental amount of the period from that of
From the date of certificate copy itself of owning, demarcate the land at measuring 1 kata so and so and hand over the possession of the land to the commissioner. The district commission is very active taking the yes.
But there are two directions, and then already the land has been demarcated. And the Food Corporation of India, they were directed to demolish the land. They-
Oh, this one.
Yes, yes.
Ah, yeah.
So the
Land
land-
demarcated.
We have demarcated and we have asked them that it is within your boundary. The land has been demarcated and the FCI has been said that it is within their boundary, your boundary, you demolish the wall has to be demolished. But ultimately, they have prepared a RTP against the order. The RTP has been subsequently in the month of March, they have withdrawn the RTP. I'm just facing the order.
Yes. RTP has been withdrawn. Then
Now, well, before the before the honorable division bench, they have said that they want to withdraw the appeal with a liberty to approve the Lanet single jail
huh,
in the review hearing.
nothing is going to happen.
No.
They have not approached me.
Because of that, the handing over is not. Because of that development, handing over is not there. Otherwise,
No, hand over. You hand over immediately.
Not-
There's no review. And the review has not come before me till now. You hand over.
Not-
There's no state in that order.
not-
The instant application has been filed alleging willful and deliberate violation to the order dated 18/12/2024 passed in WPC number 3943 of 2020. Whereby there was a specific direction upon the district commissioner Kamrup Rural at Amingaon to demarcate the land at measuring 1 kata 10 lechas covered by Dag number 1693 of Patra number 331 of village Sangsari, Moza Sila Senduri Bhupa under Uttar Gauhati Revenue Circle in the district of Kamrup Rural Assam and hand over the possession of the land to the petitioner. Mr. Dinath, the learned counsel appearing on behalf of the petitioner, respondent number
But one,
Respondent number 1 submitted that already the land has been demarcated, but on account of a writ appeal being prepared, which was subsequently withdrawn, by the FCI, with a liberty to approach this court seeking to initiate the review jurisdiction. The handing over of the possession have not been carried out. Crystal. It is the opinion of this court that there is no stay to the judgment and order dated 18/12/2024 passed in WPC number 3943/2022. And under such circumstances, it is the bounden duty on the part of the District Commissioner, Kamrup Rural, Amingaon, to comply with the order dated 18/12/2024. So accordingly, list this matter again on 31st of July 2026. In the meantime, an update be provided.
Here only one respondent, the sole respondent. You see, absent or
Not necessary,
Lot.
because the direction is only for one.
Lot.
FCI, I had given him a lot of opportunity for the purpose of purchase, taking over the land. They are not bothered. They want to pay as per what they did it at that point. Good way.
But this is regarding the issuance of caste certificate. But my instruction is that the report has been called for, and that report.
উত্তর জেলা পরীক্ষা হবে।
Lot. The Honorable Gauhati Parishad has not given the report, and that report is awaited. Once the report is received, the action will be taken.
What? When did you file the application? How can it be given in 45 days?
One inquiry report from the Uttar Kamrup Jila Anususita Gauhati Parishad is required. That report is awaited. That report is awaited from the DC office. The report.
Understood. This thing cannot go on like this so soon. How much time you require?
No, the
6 months?
Committee has been reconstituted. New committee, that particular Jila Parishad has been reconstituted. New incumbents have come. They said they have fought for some time. I place the.
For verification.
For verification.
Hmm.
Once the verification report comes, the certificate will be given.
Other circle officer already submitted.
Circle officer, no means. We keep it.
Logic.
Now, this is an application filed alleging willful and deliberate violation to the order dated 10/5/2024 passed in WPC number 22463/2020. Mr. Das, tell me one thing. So many people, are they related? All are different persons have come together and filed one petition. How is it possible? Alleging willful and deliberate violation to the order dated 10/5/2024 passed in WPC number 2263/2020. Whereby there was a direction upon the respondents to dispose of the applications upon being filed in terms with the memorandum dated 8/8/2022 within a period of 45 days from the date of receipt of such applications. Mr. Dina, the learned counsel appearing on behalf of the respondent, number
Sole respondent.
respondent submits that there are altogether 17 writ petitioners.
Yes.
17 writ petitioners. And for the purpose of providing the carrying out for issuance of the certificate in terms with the office memorandum dated 8/8/2022, necessary certificates and reports have to be called from the authority. What is the name?
Uttar
Uttar
Kamrup.
Kamrup
জেলা অনুসূচিত
authority namely উত্তর কামরূপ জিলা অনুসূচিত জাতি পরিষদ. And as such, without receiving the said report, the certificates cannot be issued. He therefore seeks some more time in that regard. Taking into account the above, list this matter on 4th of January 2027 for an update.
little bit earlier, my lord, in this year.
Absolutely no.
But it was 24. my
Why
lord.
did you get an order of 45 days?
No, no, 40, already 24 already verification done.
So what?
By the,
Okay, September. 18th of September 2000. What is this?
My lord, lordship will find the order at page 13. And my lord, operative part lordship will find at page 17, para 11 and 12.
One is the list of documents which according to.
Para 11 and 12, my lord, the operative part.
Notice what is up in service? The direction was given to respond number 3. What is the document you are asking for?
Yes.
What document are you asking for?
No such intimation was made to the petitioners by the office of the district.
Huh?
No such intimation was communicated to the petitioners
Regarding?
by the regarding self permission. Self permission was rejected, saying that insufficient document. Lordship, kindly see page 12. That was the order was challenged
In
before
view of
Sonora.
the fact situation and considering the state of the representative is directed to furnish the list of documents which according to him were not submitted by the petitioner with his application dated within 7 days from the date of submission of the certified copy of the order. 3.
It was communicated on 17 to 2025.
Revenue. Additional District Commissioner, Revenue Branch, Dubri. You get your instructions why you have not done it. You give a copy to him. This court duly takes note of. That a service upon the respondents are duly complete, however, none has appeared on behalf of the respondents. The present contempt application has been filed alleging willful and deliberate violation to the order dated 5/2/2025. Passed in WPC number 6980/2024, whereby there was a direction issued upon the respondent number 3, that is the direction issued upon the additional district commissioner revenue branch to agree to furnish the list of the documents which according to him were not submitted by the petitioner with his application dated 26/7/2024 within a period of 7 working days from the date of submission of the certified copy of the order at the office of the district commissioner, additional district commissioner, revenue branch to agree. The petitioner thereupon submitted the said document, the certified copy on 17/2/2025, and the same, however, the list having not been furnished, the petitioner has approached this court. Taking into account that none of the respondents have put in their appearance, this court have requested Mr. J. Hendick, the learned additional senior government advocate, the learned junior government advocate, to obtain instructions as to why the order dated 5/2/2025 passed in WPC number 6980/2024 have not yet been complied with. So in addition to that, this court also directs the the present incumbent additional district commissioner, Revenue Branch Dhubri, to provide the list of documents to Mr. J. Handick, the learned junior government advocate, so that the same can be placed before this court on the next date. A copy of the instant petition of the contempt application be served by Mr. M.U. Mondal to Mr. J. Handick during the course of the day. Full stop. List this matter again on 5th of August 2026 for an update. Developed. The name of Mr. J. Handick be reflected in the cause list by the registry. Item?
In this case, my lord,
What has happened? IA for what?
I have for modification of the initial order, my lord, to protect the petitioner for not to evict them, my lord, from the my lord, they are apprehending to be evicted from their possession, my lord. My lord, in this case, my lord, the writ petition was essentially filed on the ground that there is a order of civil code.
Huh?
There is an order of civil code declaring right title possession of the petitioners. And there is also order of the High Court in the previous writ petition that without due process, no eviction. But in the year 2025, June 25, madam, there has been visit by the revenue officer and threatened them to be. On that apprehension, we have approached this court.
What is this matter? Forest matter?
This specific notice by the forest department. Otherwise, the directions of the Abdul Khalik will be followed. If petitioner is found under.
But have you taken any action in that regard?
So far, I don't know.
Huh?
Go ahead, go ahead.
What?
But
Also not instructed, but wherever it reaches, that's it.
our claim is that it's not a forest land.
It's okay, no problem.
And my lord, they have installed some pillars and thereby our road has been
Earlier
blocked.
suit was filed by one Sofiur Rahman.
Yes, madam.
Who is
Sofiur
the
Rahman, my
Sofiur?
lord, is the original occupier of the land, and
What occupier of the land? Now there are 46, 47
Yes,
people.
yes.
How are they related to Sofiur Rahman?
my lord, the land, my lord, is 16 biga, and some portion of the land of the Sofiur Rahman was sold to this rest of the petitioner. 1 to 3 of this petition, they are the son of the Sofiur Rahman. Others are others have purchased
Others
land.
have no business out there. Sofiur Rahman is different, others are not. Show me the sale deeds by Sofiur Rahman's people to other people.
My lord,
Where are the sale deeds? Huh?
No,
Where?
no sold.
Don't come up with these type of things. I think we strike out the names of the other respondents. Only for 1, 2, and this type of case, what do you do is get hold of all these other people out there, make them anything out there. Isn't it, Mr. Botakot?
Yes, ma'am.
Huh? We have to take serious note of this. One person gets a decree, some order or decree. Some person moves it. We have to show the relation out there. And they say they sold. Sold means if he has title over that and he has sold it, he must have sold it by way of a registered document. And we strike out the other names and throw out these people by Abdul Khalid. What?
My lord,
I think
let me have an instruction, my lord.
no. I think this cannot happen like that. Covered by Tozi, 95. How did Sofiur Rahman get a degree? Let's see what degree.
My lord, in annexer
What
4 of the
degree?
petition.
The dispute is for declaration and for perpetual injunction. It appears that if land is
Concluding part
recorded
of the
as
judgment is at least
and
60.
the Wilson settlement itself, the suit is barred by 58 The suit is grounded for according to the court of action from the group. Not the. Okay. So the trial court dismissed your suit.
Well,
Let's see the appeal.
appeal was, my lord, in our favor. And it's
Uh,
court page 51, the, my lord, 11, my lord, and operative
appeal is
person at
allowed
page
around
60.
so and so. Declaring the appellant has right title and possession over the suit claim described in the schedule on the strength of previous possession and restraining the defendant and encouraging them. Evicting the so and so and his promise from the suit claim. Where's the decree?
Well, my lord, on page 61,
Decree,
decree, my lord, page 61 onwards,
where is the schedule land? Decree,
my lord,
where? Schedule land?
Well, decree of the appeal, my lord,
The decree doesn't contain a schedule. What type of decree is there? Effective decree. Thing which nobody knows what is the land. Sixteen bigas under Tozi 95. 1,500, 2,000. And 16. So this is of 16 bigas of land.
yes, ma'am.
And if it is Tozi, obviously it is a set. It cannot be the forest.
Yes, ma'am. That is our stand, is never punishment.
It is mentioned anywhere that it is not a forest land.
My lord, we have
Where?
stated in the IA also. as
Not
well as
IA.
In the
In the
petition also.
decree. Yes, what type of judgment is this? They can appeal also file.
My lord, we have not filed any, no second appeal.
Who has filed it? Here receipt and pay pending.
Appeal was filed by
After hearing the.
Severe.
So earlier nothing. Now when notice for final master plan of. Where are the notices?
Notice not issued.
Then why are we here?
My lord, they have visited the site,
So what?
visited this and threatened them to evict. On apprehension, they have.
Nothing. They will do as per Abdul Khalid. We dispose of. But the others, they don't have any like.
My lord. 1 to 3, my lord.
No, they will also have right as per Abdul Khalid. If it is a government land, if it is not a government. Now, if it is a reserve forest land drawn with the boundary, it cannot be a tozi. It cannot be a collection of tozi. Tozi can be only collected by the revenue department. The forest doesn't have the business of collecting tozi. Well, they don't have the power to collect the tozi. Anyway, heard Mr. A.R. Sikdar, the learned counsel appearing on behalf of the petitioner, Mr. Aibot Thakur appears on behalf of the
3, 5,
appears on behalf of the forest department. Mr. J. Hending appears on behalf of the district administration and Ms. So-and-so appears for the revenue department. The present writ petition has been filed by 47 petitioners, claiming that they have a common cause of action, apprehending that the petitioner, apprehending that the respondent authorities, more particularly the Forest Department of the Government of Assam, would evict the petitioner without following the due process. It is relevant to take note of that as on date, there has been no notice issued either by the Revenue Department or by the Forest Department, either by the district administration or by the Forest Department to evict the petitioner. In a recent judgment passed by the Supreme Court in the case of Abdul Khalik versus State of Assam and others reported in so-and-so, the Supreme Court had laid down certain guidelines on the basis of which eviction from reserved forest land can be carried out by the Forest Department. Mr. Aibot Thakur, appearing on behalf of the Forest Department, categorically submits before this court that in view of the directions passed by the Supreme Court in Abdul Khalik Supra, the Forest Department, if initiates any action for eviction, the same shall be done in compliance with the same guidelines. Taking into account that the state stand of the Forest Department, which is placed before this court, the apprehension of the petitioner to file the present writ petition is misconceived, for which the instant writ petition stands this, for which this court is not inclined to pass any directions in the instant proceedings. Accordingly, the writ petition stands closed. Before parting with the record, this court, however, observes that in the circumstance, the Forest Department of the Government of Assam takes steps for eviction of the petitioners. The same shall be done so by following the guidelines as laid down by the Supreme Court in Abdul Khalik Supra.
My lord, our stand, my lord, our claim is that the land is not.
Everything will be considered there. Abdul Khalik clearly mentions. They will issue notice, you give all your reply, say everything, then they will pass speaking order, then 15 days, we are here. Nice things. Correct. In view of the judgment order passed in 7 lines.
Okay.
What is this? H. Gupta, Lalit Council for the petitioner, and so and so forth. What is the matter about? Ah.
I'm sorry. My lord, the grievance is not the petition with my lordship is the IOCL. My lord, there is a IOCL refinery, my lord, in Betkuchi. My lord, just, my lord, within 100 meters, my lord, there is a high-rise building being constructed. And my lord, our, my lord, contention is that
Who are you?
IOCL.
Okay.
The permissions, my lord, which were granted, you know, when we for making building permission, my lord, that was without considering the fact that, my lord, that the oil refinery is situated near the vicinity. My lord, that can be, my lord, it's storage center, not refinery. No, it's a big storage center.
Much big. I still remember. Remember, this thing must have happened sometime in the year 1998. 98. Yes. Near that area pertaining to Tekaraguri.
Yeah, that was Because that alpha attack, man.
What do you mean? It's not on there. That is also not a refinery, it's a story.
Storage tank. Similar with the storage. Near that
So, and
temple.
and did you ever visit at that point of time? All roads were closed for almost 10
Now it is abandoned now. Now it is-
Really, all have to be then going through Muiga.
Yes.
Because that area could not have been gone into at that point. Anyways, who has filed, who's building the house? Ah. What? 1 to 4. Then you, and environment is there. GMDA, why are you making all these people a party? Why are- these are the
GMDA GMC party because the
police,
NOC is having strict parade.
why are you making everybody a party? But all the necessary permissions were granted by these authorities, the fire and permission. Yes.
CI is also there, not state
So
environmental.
you have challenged all these different permissions.
Yes, no.
Fire had given permission. Fire is who?
Fire,
Fire is Mr. SS Roy.
government, by government. will-
SS Roy will be fire. Revenue is who? Revenue has no business. Pollution is Mr. Ezbula. Ezbula, what does pollution have to do? Huh?
Environment clearance.
Pollution is, that environmental clearance is required.
Okay, pollution. And then you are the main person.
No.
Yeah, you have given the building
Yes,
permission.
NOC has been issued, but
You file your affidavits.
there are lots of allow me sometimes to file my affidavit.
So all are representing. And why the police?
Not, we have all, because my lord,
Means you go everywhere. Why not
my
the
lord, the
president of
problem is,
India?
my lord, due to the construction, my lord, will see this photograph, my lord. The
This-
boundary walls are being damaged, my lord, the vehicles fully loaded with oil, my lord, tankers
No,
are.
all are understood, Mr.
We
Council.
have given representation, my lord, that is why.
After making of this building to this size,
2020
this
NOC,
is a repetition of when?
2025.
25.
Why you are filing it so late?
We have been representing, my lord, to authorities, several representations made.
Now,
my
how
lord.
can it be built up, demolished? Now tell me.
Look, we are not on demolition, my lord. The safety concern, that ought to have been taken into concern, my lord. That has not been, today, my lord, even today, this boundary wall is going to be damaged, my lord, due to the construction. And the vehicles are, my lord, standing just besides the boundary wall where the construction is going on. And at least that direction must be issued, my lord, that they should not damage the boundary walls, my lord, and they should ensure that the boundary wall is intact.
So you have come so late.
Well, we have been representing, my lord. I have next all the representations.
Presentation is done.
None of the
Building has
represent-
become so big. Anyways, you file your affidavit. So and so, so and so, so and so appears. Give your names. On behalf of the respondents, the learned counsel submits that they would like to file their replies to the affidavit, file their affidavits. 1 to 4 AM. File their affidavits. Considering the above. Mr. H. Gupta, the learned counsel submits as there are no interim orders passed till date. The matter requires an urgent disposal. This matter again on 28th of August 2026. The affidavits be filed by all the respondents be filed. A final opportunity is granted to all the respondents to bring on record their stand by filing their affidavits on or before 18th of August 2026. Reply thereagainst be filed by the petitioner on or before 27th of August 2026.
I pray, my lord, that the builder should ensure that the boundary walls, my lord, should not be damaged, my lord. It is in a very dilapidated condition, my lord.
Why you are not building it? Who has made the boundary walls?
No, that is our boundary wall
So
now.
make it proper. Also, pendency of the instant writ petition shall not bar the petitioner from repairing the boundary walls which have been constructed by them.
Malad here in this requisition. An order of Assam Board of Revenue was challenged on the ground that the petitioner is the Malad registered person of a plot of land. That based on the salary Malad, his name was Malad mutated in the record. That was
Which is the
challenged.
order?
Not
Which is the
sure find-
order of the Board of Revenue?
That page number 50 to 53, Malad. Prior to this order, Malad, there is another order passed by the additional district commissioner. That additional district commissioner, Malad, set aside the mediation, my mediation order. That was challenged before the Assam Board of Revenue. The Assam Board of Revenue also, Malad, did not interfere with the order of the additional district commissioner. That is the case here. Malad, the original patadar had 2 sons and a daughter.
What is wrong with the order?
Malad, here the case is, Malad, my mediation was granted based on the salary.
Huh?
I am the registered purchaser of a plot of land. Based on the salary, my name was mutated in the record. As a registered purchaser, registered owner, Malad, I constructed my house. I've been residing. I've been in possession of this land, Malad. Now, one of the legal heir of the original patadar, at the time of registration of the salary, her name was not entered in the Jamabundi. Subsequently, she came, filed an application before the ADC, claiming that she is one of the legal heir of the original patadar. So, since she did not sign the salary, he was not consenting to the salary. So, the mediation granted based on the salary that should be cancelled. ADC allowed that application that was challenged before the Assam Board of Revenue, and Assam Board of Revenue did not interfere with the order of the ADC. Now, my case is here. Since mediation was granted based on the salary, because this is an automatic process, once salary is executed, mediation will follow based on the salary and position. Mediation was rightly granted. Now, if one of the legal heir is not consenting to the salary, she might have approached the civil court, either challenging the salary that was not challenged. Since salary is not under challenge, the mediation granted based on the salary that also cannot be interfered with. That is my case here. Now, the original patadar had 2 sons and a daughter. After death of the original patadar, 2 of the sons, their names were mutated. They mutated their names in the record, and they executed the salary. Received the full consideration amount, executed the salary. Now, the married daughter, she came later on. After execution of the salary, after mediation was granted, she came later on, claiming that I am a married daughter since I have been residing far away. So, and my name was not entered in the Jamamati because of the 2 of the sons, they did not enter her name. So, ultimately, she filed the application before the ADC. That is the case. My submission before this court, since the salary on the basis of which mediation was granted is not under challenge, was not challenged by the.
By paying for?
Respondent about daughter of the owner.
You were the person who filed that application before the ATC?
Yeah, prior to partition of this land and without getting any NOC, they have sold the property to the.
But for that you have to challenge the sale. How can you challenge this?
Before the partition, my lord, that they sell the property. Before partition. Before partition, the property.
Section 44 is there. Undivided share can be sold. If the
But
entire sale
they are
has
not
been
getting
made,
the
then
NOC,
also,
NOC from.
no, if the entire sale has also been made,
Yes.
then also the mutation you have without a challenge to the sale deed remains. When was the sale deed executed?
The civil nature, my lord. Pure
It's civil nature. So if it is civil nature, the revenue authority ought to have looked into that aspect. Without a challenge to the sale deed, how can the ADC interfere with? Yes, your name was not inserted in the record of rights then.
No, I have mitigated my name in the year of 2012.
2012,
12.
and notice was issued when?
Sell deed was sell, her name was mitigated in 2012, what he is admitting. Sale agreement was made in 2002. Sell deed was made in 2008.
So sale deed made earlier, and the
Eight.
first mutation,
And first mutation, my lord, it is 2000.
15,
14 May.
14. So at that point of time, her name was there.
Here,
The why notice was not issued to her.
my lord, because in the sale deeds, her name was not there. In the sale deeds, her name was not there.
Without,
No,
without my
that is not
knowledge, without
necessary.
any information, without taking NOC, my lord, they have.
No, sale deed is okay. I'm not saying anything on the sale deed. But as on that date on which the sale deed had happened,
My lord,
her name was not there.
not there.
But her name was entered in 2012.
12.
You approached for filing an application for mutation after that.
Yes, my lord.
You are required in terms of section 51 within 6 months.
My lord.
Isn't it?
Right.
In 6 months, you should have filed the application. You did not file. You
Right.
filed later. Now, at the time when you filed later on, wasn't it required for them to issue a notice upon all the patadas?
Yes. But there is a provision in the Assam Board of Revenue also that agent I am not holding the books. In that provision is matter. Based on the sale deed, my lord, the revenue authorities they should collect the report from the sub-register office.
That is 53A.
Yes, from time to time.
53A permits
Yes.
that
Any
without
changes.
even an application, the registration can be done. The
Yes.
mutation can be granted.
Yes,
There's no
madam.
quarrel with that provision.
Yes, madam.
But the moment you are issuing a notice,
Madam.
you are asking for mutation, it is also the mandatory nature that notice has to be received by sent to all the patadas. Her name was there in the year 2012.
Sale deed was.
Here, the Board of Revenue makes it very clear. You can very well file an application.
Madam.
This authority makes it very clear. The appellant is at liberty to approach the circle officer and shall on application proceed in accordance with 53. Rightly so, after serving notice to everybody. Why should we interfere with this order? You can very well file an application there. Makes no sense keeping this matter pending out here
Yes. We come to the appropriate.
without prejudice. Means it shall not cause any prejudice. The orders or the direction, here also, kindly see paragraph 7 of the order, impugn order at page 53. A cautioner may under section 44 transfer alienate undivided interest. Such transfer, however, does not by itself confer exclusive right over a defined parcel unless and until the estate is partitioned. So you may have a right. Now, if you want a separate dark number out, if there is a dwelling house, it's a different thing. If it is not a dwelling house, then if it is only the plot of land out there, you can very well have a right over the land. Ownership. If you want to partition it out, then it's you have to get a partition under section 100 of the.
That is the supposed part. That is not. Here my only case is very simple. That suppose at this stage she make an objection before the circular officers. That mediation should not be granted. She is objecting. Whereas I am the owner of the property by way of the registered sale deeds. My residential house is there. I have been residing there. Now the process is the mediation will follow the registration. If At the time of registration, she was not a party. Her name was not in the Jama.
No, she was there. That is what I'm saying. At the time of mutation,
She was
in
there.
2015,
She was there.
her name was inserted
Yes.
in 2012.
Yes.
So without issuing her notice, how could there be a mutation?
Suppose she again make an objection. Before this circumstance, the mediation should not be granted because she is contesting.
How can they make an objection before the circle officer after the order has been passed? The circle officer becomes functions officio. She has to file an appeal, and accordingly, she has filed an appeal. And the appeal was allowed.
Yes, ma'am.
And against that, you filed an appeal, your appeal was dismissed.
Yes, ma'am.
So therefore, rightly so dismissed. You have been given the liberty to go there, file it. Now, without a challenge to the sale date, you always have a right over there.
Yes, ma'am.
But without a notice, is the mandate of the law. Now, the problem is, if I was sitting at the Board of Revenue, I could have made the correction itself and say that, okay, her presence is there, her name will also continue. Your name will also be there, but shown as an unpartitioned, in the unpartitioned estate.
Yes, ma'am.
Your name will be there, her name will be there. At the Board of Revenue, I could have. But I, as a in a writ petition proceeding, I have no right. Because why should I exercise my writ of certiorari against an order which is otherwise legal?
The only issue is not again, if I make an application fresh manner. If I make a fresh application for mediations, because she is contesting since early.
She will contest there.
Not
You
not
fight
only
it out.
contesting,
I'll
even
make an observation.
in different ways also.
I will make an observation that he has a right.
Fine.
By his name having been inserted in view of section 44, you have a right.
Fine.
There can be a sale. There is no quarrel that there cannot be a sale. Can be a sale. You have a right to be. But then also, you have to go and file a mutation.
Makes sense.
That is the best option. Urge Mr. So-and-so, the learned counsel appearing on behalf of the petition. Mr. S.S. Roy appears on behalf of the respondent number 2 and 3. P.M. Hunter appears for respondent number 1. Ms. So-and-so appears for respondent number 4. The respondent number 5, 6, and 7 have not put in their appearance. The present petition has been filed assailing the order dated 15/7/2025, passed in 97 RA bracket K 2018, whereby the learned Assam Board of Revenue dismissed the appeal filed by the petitioner, thereby affirming the order dated A5/2018 passed by the additional Deputy Commissioner, Kamrup Metro, in RA bracket M number 3/2015-16. The materials on record show that pursuant to an deed of sale agreement dated 12/10/2002 entered into by and between the petitioner and the respondent number 5 and the predecessor in interest of the respondent number 6 and 7. For sale of 10 letters of land out of 2 Katha 10 letters covered by Dag number 1341 of Pata number 194 of village Satgaon under Moja Beltola a deed of sale was, registered deed of sale was executed on 12th of March 2008. In pursuance to the sale, deed of sale, the petitioner filed an application for mutation before the Circle Officer, Dispute Revenue Circle. The Circle Officer, Dispute Revenue Circle, by an order dated 23/2014, how much land is this?
Only 10 kada madam.
10 lakhs.
Say 10 less, out of you got a 10 lakh. And even if partition is also made, my lord, since there are 3 legal heirs, so still, my lord,
Pursuant to the said deed of sale by an order dated 23/2014, the plot of land at measuring 1.34 R out of 6.21 R of dag number 1429 of patta number 496 of village Satgaon under Moza Beltola was mutated in favor of the petitioner. It may not be out of place to mention that at the time when the order dated 23/2014 was passed by the Circle Officer, Dispute Revenue Circle, the name of the petitioner was already mutated over the said land, along with her brothers. Brother, na?
here the respondent number 4. In place of petitioner, the respondent number 4
Respondent number 4.
With her brother,
brothers.
with her brothers. That is the vendors of the petitioner. However, without issuance of any notice to the petitioner, the said mutation order was passed on 23/2020
Not to the petitioner, to the respondent number 4.
to the respondent number 4.
Respondent number.
The notice was, the impugn order dated 23/2014 was passed. The respondent number 4 being agreed, preferred and appealed before the learned additional deputy commissioner, Kamloops Metro, challenging the order dated 23/2014 passed by the Circle Officer, Dispute Revenue Circle. The said appeal was allowed by the order dated 8/5/2018. It was, the appeal was, and the appeal which was registered and numbered as RA bracket M number 3/2015-16. The said appeal was allowed by the order dated 8/5/2018, thereby setting aside the said mutation made in favor of the petitioner solely on the ground that the said mutation granted in favor of the petitioner was without notice to one of the patadas, one of the co-owners. An appeal thereagainst was filed before the learned Assam Board of Revenue, which was registered as case number 97 RA bracket K oblique 2018. The learned Assam Board of Revenue, by the impugned order dated 15/7/2025, dismissed the said appeal, and it is under such circumstances the present petition has been filed. The question arises in the instant proceeding as to whether this court, in exercise of its jurisdiction under certiorari jurisdiction under Article 2 to 6 of the Constitution, should interfere with the impugn order dated so and so passed by the learned Assam Board of Revenue. Section 52 of the Assam Land and Revenue Regulation 1886 being relevant is reproduced herein under. From a perusal of the said application above quoted provision, more particularly subsection 1 of section 52, it is apparently clear that upon receiving an application, the Deputy Commissioner is required to publish a notice requiring all persons who object to the registration of the name of the applicant or who disputes the nature or extent of the interest in respect of which registration is applied for to give in a written statement of their objection and to appear on the day to be specified in the notice of not less than 1 month from the date thereof. In the instant case, as the respondent number 4's name was already mutated along with the vendors of the petitioner in respect to the same plot of land, irrespective of the fact that only a portion of the land have been sold to the petitioner. It was the requirement of law that notice ought to have been issued to the respondent number 4. This court have duly taken note of the order dated 8/5/2018 passed by the learned by the additional Deputy Commissioner Kamrup Metro in RAM number 3/2015-16, and the additional Deputy Commissioner Kamrup have duly applied by duly applying rule, section 52 of the regulation, had held that the mutations were carried out without issuance of notice to one of the co-owners of the land was in violation of section 52 of the regulation, cannot be said to be wrong, incorrect. This view, the said aspect have been affirmed by the learned Assam Board of Revenue. So this court have also taken note of that the learned Assam Board of Revenue, despite dismissing the appeal filed by the petitioner, granted the liberty to the petitioner to approach the circle officer dispute for mutation afresh. Under such circumstances, this court therefore does not find the present writ petition to be a fit case for being entertained. Accordingly, the instant writ petition stands dismissed. Before parting with the record, this court, however, makes it clear that the dismissal of the instant writ petition or the appeal filed by the petitioner before the learned Assam Board of Revenue shall not prejudice the petitioner to claim mutation on the basis of the registered deed of sale bearing deed number so and so, deed number
4104, 2008,
of 2008,
dated 12/3/2000,
dated so and so,
12/3/2000.
in respect to a part of the land covered by tag number 1, in respect to a part of the total land, that is 10 lechas out of 2 kathak to a 10 lechas covered by tag number 1341 of KP Patra number 194 of Revenue Village Hatgaon under Muda Beltola in the district of Kamrup Metro, Gauhati. The number has changed.
My lord, this is the earlier Dagnol Pata number.
So it is now a bracket of the black number, Hetudia number 1429 and Pata number 496. So new.
All right.
What is this? Dismissed for non-prosecution. Why?
I have given the ground, my lord, in paragraph number.
Matter pertains to a claim of equity of 2 lakhs on account of the death of the husband of the year in a road accident. Upon pleading, it is seen that even the that privately the case may not grant to the opportunity. What is that?
So, my lord, paragraph number 3. All along I was inside the court, my lord. Letter was, my lord, dismissed
What?
for non-prosecution, my lord.
And otherwise also you don't have a case.
Yes, ma'am. That is correct, ma'am. Otherwise, there will be no relief in my main case.
So you want to remove,
Yes.
why you,
Forest,
what does forest have to do?
this petrol depot was found to be inside forest.
What? Yeah, there is no forest business out there.
It's the next step.
Very well. We do one thing. We restore and dismiss. And there is nothing out there. What is there? Rightly so.
Otherwise, it was.
It is, this cannot be restored. It's a case of review. You can't restore it. It's on finding of merit. It's on merit. Kindly see, upon perusal of the pleadings, it is here.
Non-prosecution, matter. Page 11, ma'am. Due to non-prosecution. Page 11.
Hmm?
Page 11 of my miscase.
What?
It was, my lord, dismissed for, my lord, non-prosecution.
Okay. Part Mr. So-and-so, the learned counsel appearing on behalf of the petition applicant. None appeared. Anybody appearing? Want the disposal? Anybody? They don't need to know, nothing. Okay, Mr. S.S. Roy, the learned state appears for the state council. Revenue, anybody from revenue? Ms. So-and-so appears for the revenue department. There's an application for restoration of the repetition being WPC number 4741 of 2023, which was dismissed for non-prosecution by the order dated 29/1/2026. This court have duly perused the reasons assigned in the instant application and is of the opinion that the reasons assigned as good causes constitutes a good cause, and accordingly, this court therefore restores the petition back to the file of this court. I stands allowed. Meanwhile, it is a production list for and Art Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy, the learned counsel appears on behalf of the respondent numbers. Ms. So-and-so appears on behalf of the respondent number 1. Mr. So-and-so appears respondent number 2. Mr. So-and-so appears for respondent number 1, 4, 5, 6, 7. Alia appears for respondent number 3. Judgment, this one order, this one is an application filed by the petitioner claiming ex gratia payment on the basis of the notification dated 15/11/2014 on account of an accident, on account of a road accident which led to the death of her husband, na?
Husband,
Of her husband. এটা পুরো অর্ডারটা আছে না? Where is the judgment? By Justice Surana?
latest one in my own case, this was.
Ah, very good. You would have shown me that they
One of the matters were has traveled to Supreme Court.
I don't write so much. It has been brought to the notice of this court that a learned coordinate bench of this court in a judgment and order dated 21/6/2024 rendered in WPC number 2700/2023. Second, Monisha Khatun and Elias Manusa Khatun versus State of Assam and others. Considered the question whether the petitioner therein would be entitled for ex gratia amount as per the notification dated 15/11/2024, when just and fair compensation for an accident involving motor accident could otherwise be claimed before the Motor Accidents Claims Tribunal as per the provisions of the Motor Accidents Act 1988. The learned coordinate bench had proceeded to observe that the relief provided by the notification dated 15/11/2014 could not embrace all persons suffering from any accident except hit-and-run cases where the offending vehicle remained unidentified in the final form after police investigation. The proposal which is discernible from the said decision is that other than the hit-and-run cases, a person who met with a road traffic accident, wherein the offending vehicle has been identified, would not be entitled to ex gratia relief as other statutory remedies are available. In the instant case, taking into account the said aspect, in the instant case, the vehicle in question which led to the accident was a dumper bearing registration number AS01JC/6625. Under such circumstances, this court is of the opinion, is of the view, and this court does not find any other good ground to differ with the law laid down by the learned coordinate bench of this court in the case of Monisha Khatun Supra, and accordingly do not find the present writ petition to be a fit case for which the writ petition stands dismissed.
There was another writ appeal.
Accordingly, the writ petition stands dismissed.
There was another writ appeal.
Huh?
Writ appeal was there.
I know that.
Same like.
It's okay. That is different, but you see, although I don't primarily agree, because you see, I don't know, government of Assam has so much of money nowadays to give all these things. Today, a hit and run accident also, a person is entitled to something around 5 lakhs. It is being given as per the corpus, it's given under 164. Item 17, who is there? Mr. Biswas. What is the matter about?
I read the order of the Assam State Women Commission. They
Assam?
have summoned me. I am a state officer of NFW. We have requested to initiate an eviction case by a state officer to vacate the railway land. And that she has alleged that she was misbehaved. That is the allegation made, my lord, at page 24. Insulted and misbehaved. They have not filed an affidavit till today. And one case I got from Odisha.
Well, I am appearing on behalf of the respondent two, my lord.
Yes.
And as per instruction of my respondent two, my lord, the case has been settled, my lord, between the parties outside the court, my lord. So, my lord,
Oh, that observation.
only when the case of misbehavior itself. Misbehave case, my lord, misbehaved by the petitioner to the respondent two, my lord.
That
So when that case, matter has been settled, my lord.
So, so
Yeah,
if
make it
it
clear.
had been settled,
Yes,
then we close the case then.
yes, my lord.
The case. What is this? On one hand, again, aforesaid proceedings against the private respondent being carried out while performing officially in strict compliance with the provisions of the public premises and in regular course of business. Who are you? You are a woman.
I am, my lord, the one of the, my lord, women organization of my lord, member of. So, my lord, we have,
Who is the respondent number two?
she is Niruja Das, my lord.
these are the
They have
JB, my
occupied the
lord.
railway land, man. That's why.
Occupied, my lord, earlier, my lord, that occupied room was, my lord, vacated, my lord, in the year 2016, my.
Then
Then, my lord, now, my lord, that matter has been already, my lord, settled, my lord.
But against that, she has filed complaints with the Women Commission.
So after that, my lord, regarding misbehaving by the petitioner to the response to my lord, she has filed this application before the Women Commission, my lord. So, my lord, that matter has also been, my lord, settled between the parties, my lord. As per instruction of my client.
the president heard Mr. S.C. Biswas, the learned counsel, appearing on behalf of the petitioner. Mr. Assam State Women Commission, anybody is appearing?
No.
You. Mr. So-and-so appeared on behalf of the respondent number one. And Ms. So-and-so appeared for respondent number two. The present application has been filed alleging, challenging the complaint proceeding being case number ASCW.245/2014, which have been initiated by the respondent number one on the basis of allegations made by the respondent number two. Ms. So-and-so, who appears on behalf of the respondent number two, submits that the matter has been already amicably settled between the respondent number two and the petitioner.
Yes.
And therefore nothing further remains. She further submits that the said complaint proceedings being case numbers ASCW.245/2014, therefore no longer continues. Mr. P.K. Medi, appearing on behalf of the respondent number one, however, submits that he has no instructions. Instruction? No instructions. No instructions. Considering that the matter between the petitioner and the respondent number two has been amicably settled, that it is the opinion of this court that, therefore, opinion of this court that the further continuation of the complaint proceedings of case number ASCW.245/2014 cannot be allowed to be continued, that it would amount to abuse of the process of the court. Accordingly, the said complaint case proceedings being case number so and so stands squashed. Yes, Mr. M.J. Burwa, what is this?
My lord, this is the.
Anything to do with Fancy Bazaar? Another one?
My lord, he was a, my lord, purchased a land, my lord, that land become now road. No, my lord, LA proceeding. That is why he appeared before this honorable court. Last
You
occasion,
purchased the land and the land became a road.
yes, public road, but no land acquisition proceeding. Although there is a suggestion from the commissioner that LA should be, DC should start in LA, but nothing has been done. But petitioner has, so.
What is it?
EMC has no role to play, my lord.
Yes, yes.
So they have filed an affidavit, I think. PWP, but revenue has started proceeding, my lord. They have filed an affidavit says that yes, it is a public road. No LA proceeding has done.
Who says?
My lord, the circle officer, concerned circle officer.
Okay. Now, has the circle officer submitted the affidavit
Yes,
as to whether the land where the road is and your land are different land?
my lord, that way they have not done.
That is the only question.
Yes, my lord.
Circle of the response number 4 is who? Circle officer. Huh? You are who? You are revenue. Respondent number 4 is PWB. You are PWB.
I filed an affidavit on behalf of the circle officer, Your Lordship.
Circle officer
On
is
behalf
not there.
of the revenue department, Your Lordship,
Oh.
only take the.
We don't have the revenue department here. Oh, you have filed on behalf of the revenue department. And what is this money suit for?
Money should, my lord, this was speech director thinking that money will be given by PWD. So it was, that is what dismissal as the owner of this land. So this under of
While going through the judgment on the numerous deformity in the so-and-so was observed in respect compensation given by him for the proper doing the transition point of so-and-so certain limitation property. First, she Who is the response number 4?
Man, executive in the PWD, man, I'm sorry.
Of response number 1, Para. The report of the head before the field inquiry which is found that the petitioner do not have any physical probability proper limit abiding. Where's your sale deed?
My lord, sale deed is page, my lord, 30,
Page?
31, 31, 31 and 39, 22, my lord.
Huh?
22, annexure A. Kalika, the, from Kalikanto, Adhikari, we have purchased 15 letters of land, my lord.
Where is the schedule? Tag number
When
261 of Iman of Iman.
29, my lord, 261, that number,
And this is a different land.
Yes, sir. A different.
my lord.
No,
260,
it has been changed, I suppose. Name must have changed. The number has changed. This sale deed must have occurred long time. What is the present number?
Of 99. Say it was of 99.
New is 1035. 1035. 10. Where's the public road? Where's the public road?
public road, my lord, this, my land is public road because, my lord, kindly
Ah.
page 37. Page 37, the executive engineer has said that I required your land because of expansion and we are in a hurry, kindly give us possession, and we have given possession. Then, my lord, page 37 then. That is a request from executive. Minister program is there, he was in a
No,
hurry. and-
it's okay. My question is, here they say, kindly come to paragraph 6. paragraph 6 or page 88, the answer states that in the state field inquiry of the it is found that the petitioner so and so do not have physical possession of a man of 1381. And how does 1381 come into the picture again? Huh? Is it 1035? How does 1381 come into the picture?
Resettlement operation, my lord, ends in 2009. It was 2004-5, my lord.
Hey, Mr. MD Bulwa, very difficult to do matters with you.
Yes, my lord, I have applied for Chitha, my
You are in a state of confusion. You make the court a state of confusion.
my lord. So, my lord, may I make a request, my lord?
Yeah, please.
Yes, my lord, I have already applied for certified copy with a, my lord, if I allowed to.
You just find out as to whether your land is in, land has been taken by public road is in 1035 or 1038 or as to whether 1308 is your land.
Yes.
It's such a old matter. Does it look nice?
My lord,
After 10 years to find out?
reply, my lord,
Yes.
Suppose the reply affidavit, your lordship, long ago, they were seeking time, your lordship.
10 days time may be given. I have already find those documents. I will clear, my lord. Otherwise, that is confusion.
There was a personal appearance called for in this matter, lordship. Thereafter, the affidavit was filed on behalf of the revenue department. Thereafter, the petitioner sought time to find a reply. 2024 October. Till date, your lordship, no reply has been. And today the matter is raised.
Petitioner was bedridden, my lord, in Nalbari, and I just cannot come. But my lord, layout commissioner says that our land is acquired, so deputy commissioner has to take a, lord commissioner will space 41, my lord, and excel. She made an inquiry. So probably our
What is
land
the
is
petitioner's name?
Girish Chandra Deka, my lord.
Girish Chandra Deka.
Yes, my lord.
No, here the question is, the land in question, which is under the public road must be a part of the land of your,
Yes, purchase land.
your predecessor.
Yes.
He must have more land. Your land is less than that,
Yes, correct.
and it is a different plot of. Here it says 2.55 hours covered by dark number 261 old. Which 261 old must have more land.
Yes.
1381 new.
Hmm.
Now yours was also, your dark number is
260.
1035.
Yes.
Then 261 old, but 1035.
Yes.
No case. I think we dismiss it.
My lord,
Enough.
may
No. No, enough.
then where my
I think
land goes?
this is matter is over.
Where my land goes, my lord, then, and what is about
No, no, the reason is this. Kindly see,
my lord,
page 36.
my lord?
This is your land,
Yes,
15 lessers,
my lord. 261.
261, 684, 1035.
Yes.
Land which is under here, the public road is not 1035, it is 13 138981.
1388. Yes.
81.
Yes.
So 1381 has no business with you.
Yes, correct.
Then
But what 1380 is my land, and my lord, kindly
your land is 1035.
after that it may be changed, my lord.
You may have changed means when have you changed? You
That
have
is-
not mentioned it.
Yes, that time I have not mentioned, but if I given a chance, I can give
You
the
got a chance. You
Wait,
got
wait.
a chance in the year 2024.
my lord. That
2
time
years.
I have taken the, he was not traced out because 2016 I have filed case, 2024 they filed affidavit. After 2016 to 2024, 8 years. So I have taken 1.5 years. I am sorry for that. But my lord, page 42 kindly see, my lord.
You filed 2016, they filed in 2024.
After personal appearance. And I have not responded to 2025, my lord. This is I want to respond. My lord, page 42, kindly see. Lord Commissioner says that our land is acquired, my lord. Page 42.
That is a different. My question is whether the land has been acquired or not.
Yes, 261 land, whether our portion is fall in this, that I have
That's
to
it.
satisfy. So kindly give 2 weeks time.
Lordship may
If
have
I
page
cannot fail, then your
92
lordship.
Of that affidavit, page 92.
I've read that.
Page 3, that is the report of the circle officer to the APC, your lordship, that is,
No, I've read that. I've read that.
Chita is also annexed, your lordship,
I've read it. Annexure, page 91 also makes it very clear.
is 95.
So therefore, you see, you kindly see page 91, it makes it very clear. Tag number 261 old, that became 1381 new.
Yes.
And yours is 131035.
10.
Then
Different land, maybe, but 261 is, 261 is acquired. When our portion is acquired, not, I may be given
so
a
this
chance.
is the code to find out.
Yes, I will file from documents, I will satisfy if I can. I
When do
think-
you want? Up 2 years.
No, madam.
No, no, 2 years.
2 weeks, madam. I'm sorry for.
We have to give you a half of it. 2016 and 2020. It was 24, 8 years.
8
So
years.
we fix it in the month of May 2030.
My lord, in 20 my September, my lord,
September. Okay.
September 2026.
September. You are not in urgency.
Madam?
I'm going to dismiss. This is a 2016 matter. It
Yes,
cannot go
madam.
on.
I'm grateful for that, madam.
List the matter. Will list the matter again on 2026. A final opportunity is granted to the petitioner to bring on record any document to show that the petitioner's land is presently recorded as DAG number 1381, na?
Yes, sir.
1381.
381 new.
1381. 27.
Madam, it may be 27/7, madam. That may be.
207 2000.
But because I have to, I applied, my lord.
It cannot happen. I'm going to dismiss your.
My lord. Obliged. Matter has become influxless.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous. Considering the above, the instant of petition stands closed as it has become infructuous. Interim orders passed earlier stands.
Obliged.
I stands closed. I have understood. Mr. Bodler, you give your name. 20. Where is the person? Somebody either mentioned in the morning. What is the matter about? None appeared on behalf of the petitioner on call. The respondent, the present petition has been filed by the petitioner, challenging various notices of eviction. the respondent authority, the learned coordinate bench of this court by an order dated 19/7/2016, while issuing notice, passed interim orders, thereby staying the operation of the notices, the impugned notices. But in spite of that, there has been no instructions placed by the respondent authorities. It is a settled proposition of law as held by the division bench of this court in the case of Muhammad Salahuddin versus so and so, reported in so and so, that in order to carry out any eviction in terms with section Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulations 1886, it is the requirement that there has to be notice issued, thereby granting opportunity to the respondents, to the noticee. Under such circumstances, as neither the petitioners seem to be interested in the proceedings by putting in their appearance, nor the respondents seem to be interested in taking steps for eviction, as there is no response for the last 10 years. This court disposes of the petition with a direction that in the circumstance the respondent authorities take any steps for eviction, the same shall be preceded by a notice in terms with the judgment of the learned division bench of this court in the case of Salahuddin Supra. Yes, what is this?
There's an order passed by this court. But there is a land, under the land ceiling that they have taken a land which is on excess, 216 because of excess. So ultimately, we file representation before the authority. And then we have to approach this honorable court, and there was an order passed by this court that they should dispose my representation. In pursuance to that, they found that yes, 216 because of the excess. They have taken excess, and accordingly, my lord, my name they have returned. My name appears Java Mandi, but already earlier back they have taken. Now they were encroachers.
What is your prayer?
Now
What is
my
your prayer?
prayer is to return the land vacant, handing over a vacant encumbrance free position of the land.
The response to so called as to why written the nature should not be issued, and the impugned order issued by the additional alia be set aside and quashed. And to why written the nature mandamus should not be issued directing the response to 42. Where is the order of
Now,
31?
my lord, your lordship has passed an order on 22/9/2023.
Now, my question is, where is the order of 31/5/2013?
That's at page 95. 95. Page 96 is the
In the order dated so for disposal of the land ceiling case within.
page 96 last time.
What is wrong with the order?
Then your lordship said, we said that there was maybe encroachers there. Then your lordship said that you have to make the encroachers also a party in this proceeding.
Understood, but
But
why
then
should
according- No,
we
we made.
entertain this time?
I'm sorry, man.
My question is, there was a direction, let us see the civil rules order. Page 81,
Page 81.
starts and finishes the. Then disposed of with a direction to the Iman pending, there shall be done within a period of 4 months. I have not decided the other things highlighted in the other things will follow when he decided. So and so. Where is the order?
But this is the order.
This is the order?
Yes, yes. Sealing has disposed of my lord.
No, this is an order that belongs to be civil rule here. The writ petition stands disposed of with a direction to the respondent number 2 and 3 to dispose of civil case number so and so pending before. The same shall be done within a year. I have not decided either highlighted in what. So sealing case has been disposed of. Then
Then they decided that yes, they have taken excess. 216 because has been excess. So what they have done, my lord, ultimate they have taken. When they realize that they will be difficult, so what they do it, records of right, they put our name, the guardian's name. Now they know very well that they put the name. They're shocking the responsibility to us. Now they are saying that as your name appears in records of right, that 216, that's not our responsibility because now there is no question of serving a notice under 18.3 by the state. Where is the question 18.3? Then we have the responsibility to the government land. It is no longer a government land.
right,
It is your land.
yes.
Now what I am saying, what we are saying, that you have taken that and you have returned. Now whatever peril that you have to return the land. Now what has happened in the meantime when the matter came up before this court, then your lordship has passed an order saying that there are encroachers. So you have to make them a party.
Where?
So if your lordship sees the order of 22/9/2023,
22.
9/2023, 22/9/2023.
Appearance shows that the concerned is not a party. It is seen that while alleging so and so, it has been sought for a direction of only the process of also not. Then
Now we made a party. We made them party.
but the fact remains,
Yeah.
the land was made circle
Correct.
as per the ceiling to see.
Right.
7/6.
Yes.
Then you challenge it, making it under 7/7. 7/6 or 7/7, you must have filed a review before the government.
Correct.
Government may not have decided it for which you filed the correction.
Right.
The requisition was disposed of with that order, which
Yes.
looks like a prayer. After that, he says that, okay, dispose of, thereby reverting you back the 216. Once they made the correction, gave you the benefit under Rule 5 of the Assam
Yes.
Registration of Land.
Yes.
That is done. Now, where are pattas were granted to these people?
No, that I can't, that we can't say at the present government.
Where is Rajiv Babu?
There will be a that's then it will be different altogether, my lord. And then my lord, if patta
No,
is
if
granted.
pattas were granted, the pattas will have to be cancelled.
No, I don't know, my
They
lord.
will have an impact from that.
Yes, but I don't know whether it's a patta because they.
Now, once you have made all these people a party,
Yes.
now the next question will be, have you issued notice?
No, we have made a party with justice service was also made, that is on record. They have refused. They have refused.
No, but you can't get in again every day. But the main problem lies out there is, once this is your land, then the pattas have to be, the consequential action has to be whether pattas have been issued or not. They have refused, but what is the government stand?
Nothing.
Yes, which PR Mohanto.
Let me see one instruction that
No, Mr. Talukdar, you DC. DC has no
we see
business.
that because the land is it's a transferred subject, my lord. Therefore, it has been transferred to Udalguri district.
Okay, then BTC will come in.
BTC. But BTC is not a party responsibility.
Udalguri. But how was this order being passed by the DC?
That from
What? Did it change? 2013.
2013.
2013, BTC was not there. BTC was not there.
2013, it was there. I took over. It was inserted in a 6 schedule.
Two thousand three.
Yeah, that's why.
PTC was there, then how was this order passed? If it was passed by the additional deputy commissioner, how could he pass that order? Is an order being passed under what provision? Appeal made by whom? How can you understand eviction from Pakka land of so? But the revenue is a transfer subject.
Yes.
Then without the revenue PTC, how can it be done? Constitutional misconceived, we dismiss it on that ground itself. Half of the petition is by health.
Actually,
Huh?
we are not want to blame anyone. We are not there. We are
See,
Now we have-
by one of the most that part of you have to make BTC a party.
you make a party.
You have not made the TC, you have now made the TC a party. Now my
But there was direction.
question is this.
So there was a direction.
Let
passed
us
by
first, no, let us first see under what provision this was taken over. Why, what was the ceiling case about?
Yes.
Ceiling case, scrutiny of record and the opinion that they have inadvertently handed over and reports the collector accordingly. So this order was passed in 1992.
Yes.
Okay, earlier order. Okay, no, no. Mr. Here, this is not a sealing case. While carrying out the sealing proceedings, you had no objection with the final order.
I'm sorry. No.
You had no objection with the final order.
Yes.
But 277 bighas were taken over more than the land which was there
That's the
required. And later on, it was found you submitted a representation. The representation was not considered, for which
we came to the High Court.
the first writ petition was
Yes.
there of 1991. 1991 writ petition was passed, and after passing of that order, then on the basis of that, another order was passed. That is in 1992, whereby it says that the total land was actually 216 bighas.
Yes. 216.
So now was corrected and accordingly sealing Sarkari. And I'm opinion that as an area of the was inadvertently handed over and the records were corrected accordingly as sealing Sarkari. Hence, an area of so and so be and registered in favor of so and so and record be corrected accordingly. So this land was 216, 1992 was reverted back.
Excess. It was reverted back to us.
Not reverted back.
It was
It was shown as so and so. This is now being reverted back.
Yeah.
1992. At that point of time, BTC does not come into the picture. Then after that, what happens? Nobody knows. Something happens and then 200 Pyramidi, now it is in the name of Tezpur Tea Company.
But
Banipuri,
93,
yeah, this has been corrected in Annexure F.
FA 47 minor, it was corrected in the records of right
Ah,
at page 47.
ah,
It was corrected in the records of right in the
Yes.
year 1993. So it
1990.
reflects 200 CF.
So after that 1992 order, 1993 it was corrected.
Yes.
Then eviction from here, I'm in closing, Sita, I request you to carry out eviction and hand over possession to manager so and so. So now this eviction is there, some steps is being taken by subdivision officer Udalguri to so and so. This is 1993, to
Yes.
carry out eviction.
Yes.
This was wrongly done. They couldn't have gone for that. Anyway, so then 18-2 notice was issued. Dispose of the ceiling cage. Oh. What ceiling cage? What? I don't understand the order of this. Page 81. Ceiling case has already been disposed of.
Yes.
Ceiling case has already attained finality.
Yes.
Then what is this order? Because you see, to dispose of the ceiling case, land ceiling case number so and so pending before it. Now you kindly see this. The order which has been passed by with this the division bench.
Yes.
Division bench order makes it very clear. This one. Kindly see this. Kindly come to page 36.
36.
Number third line.
Yes.
The petitioner has no objection to the sealing order and that has become final. So it became final under 7.6.
Yes.
Its contention is that in the course of the proceedings, possession of 277 bighas 2 kathas so and so of excess land was taken over inadvertently by the respondents. So that was the case. So the order which was passed by the learned coordinate bench in the year 19, whatever may be, appears to be something wrong with that. So what is wrong with this order of the deputy commissioner?
The deputy commissioner, what we are saying, it is your mistake which has been taken, with that you have taken the land excess. Thereafter, you realize and you reverted the land back to us. Now, the position which you have taken the land as on date, that was a vacant land. Subsequently, when you return back the land, because suppose the land was not returned back to us and it was a government land, and then what happens, Mike? Then they ought to have to issue a notice under 18.3 if it is a government land. Now, what they are saying in the order, they are saying, see, records of right we corrected by virtue of this order.
No. The order in 1992, the records of rights.
Right. But 1993, when he said that no, by putting it our name in the records of right, that is not enough. You have to return with possession to us. Now, what they have done, kindly see, they said it is not our headache now.
Right.
Because headache is not there, because they are saying 18.3 notice will come only in effect that if it is a government.
Yes, right.
No, it's right. Oh, my Lord, I am not saying that is not wrong. My Lord, otherwise.
Okay, let me
18.3
come at 2 o'clock to dismiss your petition. Okay. Get our go to you. So what to do? You have taken a wrong route. Your land was there in the year 1992. We are 28, 26 plus 8, 34 years. You have not taken any recourse. These people now have adverse possessions.
That's what, very honestly speaking, my Lord, that's what, when it was brief, my Lord, that's what I also asked myself, my Lord.
Rule 18, they cannot.
That's correct. That's right.
Your case should have been at that point of time, when you approached. Right. Before the single bench, not the division bench. Should have been at that point of time, either you are giving, people have settled out there, either give this land or some other plots of land to us.
My lord, very honest speaking, it will be very difficult also. My lord, suppose your lordship issue a notice that was given opportunity. In the meantime, what I have been told, very honestly, they have schools, hospitals. So how my lord, is the only way is that we have to approach the appropriate court now. Even today, 2026, whether I'll get the benefit out of not. That's the whole difficulty. No, only one, what I want to say, I know, my lord, myself, what I stand in this case. But at least the government has taken some initiative. They know also that it is very difficult. So what I do, I put their name in the records of right. Now, if I don't put record of right, then what, once the records of right it comes, my name, then automatically 18.3, they say that, no, that is true, my lord. 18.3. That no, we are starting our responsibility. Now it is the records of right. So 18.3 doesn't, where is the question of 18.3? There is no question. We know myself when I went.
No, in fact, the order which was passed by the division bench makes it very clear that 277 acres of land has been shown, you have no problem with the final settlement, final order, final return.
Right.
Meaning thereby 7.6 is okay.
Yes.
But then also, while taking possession, you have taken additionally 277 acres of land. Now, these 277 acres, you submitted a representation that was not considered, so there was a direction, and accordingly, in 1992, they considered and found out it is not 277, it's 216.
Yes.
And accordingly, the names were corrected. Your names were corrected in 1993. Thereupon, it's very difficult to ascertain what transpired in the order passed by the learned single judge, taking into account that on what basis could have been said that to complete the sealing proceeding. The sealing proceedings is already complete. The order which was passed by the learned single bench was, coordinate bench was not, I don't think, whether with the proper application of mine. Then the matter comes up again, thereafter, in view of that, again, they reiterated the same order which was passed in the year 1992 itself. It's a retreat.
Yes.
Now, obviously, you must have come. After 1993, you must have asked these people concerned out there, the authorities concerned, and the authorities also exercise jurisdiction under 18.3. And the 18.3 having not been completed, you must have approached the writ petition, most probably, likely. And after that, when the matter went back again, then they realized that 18.3 could not have been resorted. It is not a government cast land. So obviously, this court cannot direct the authorities to exercise 18.3 unless your prayer should have been that you, in the meantime, you have given some other land, the people, the lands out there, they have given patta without cancelling those pattas and all these things. Most probably, under section 16, the land must have been settled. That settlement must have been overturned in view of that.
I don't know the position whether it has been settled or not. That I can't give an answer to your lordship.
Yeah.
What I could gather, my lord, from the petition brief chronology is that my lord, the sealing proceeding was governor. Then my lord, as a fallout of the sealing proceeding, certain part and parcels of land at one point of time, which the lordship has spent it out to 277 acres. Upon verification, it was found to be 216 acres. Now, those part and parcels of land were corrected. And it was, my lord, it is a reversal, my lord, to another, my lord, one Borpukuri estate. It was corrected in the name of God. In the meantime, these persons, these respondents, private respondents came into being. Now, there is a clear finding, my lord, at page 98. This is the order put to challenge. There is a clear finding that this person of land is no longer government land now. It is not a government land. Not to speak of 18, even route 18 per se cannot be resorted. So it is a well, least simpliciter between private entities. So where government has no role. Naturally, my lord, they will have to they come up to have a the civil. This is the plain well, what I have gathered.
See, what I said, Mr. Bogudar is repeating in a more delicately fine language.
So because what I find my lord, that civil proceedings is not in dispute. So it has attained finality. 216 because of land is a fallout of the civil proceeding.
No, in fact, with the order passed by the single bench,
Yes.
the single bench order is on a different line. I don't understand head or tail about that order. The reason being that it says that it again reiterates that sealing proceedings needs to be completed. Whereas in the division bench order, it is clearly recorded at page 35,
Yes. It is there.
line number 3, page 35 or 36, at
Yes,
line number
yes.
3,
Yes.
that they have no objection as regards that particular final return.
And it is for that reason, my lord, the present is a lease where challenge has been laid to my lord that order dated 31/5/2013. Meaning they are that they are not.
31/5/2013 is nothing but a reiteration of the 1992.
So therefore, but only any presume for a moment. The petitioner is the dominant species out here. We presume for a moment that the ceiling, they have nothing to do with the ceiling proceeding. So they are agreed with the fallout. Now the fallout is my lord 216 acres. 216 acres when there is a clear finding and on the face of it, my lord, when there are no materials contrary to what has been spelled out in the my lord.
There is no quarrel with the
Yeah.
proposition that they want the 216 bigger.
Yeah.
Only indication we get after the 1943 is that there were some steps being taken by the government on the 18th,
Because
which was wrongly done.
without going to a civil suit by filing a writ petition, I will be saving some time and saving some exercise.
No, not that.
Yeah.
If you see this particular document, which
Page
makes
90.
it very clear, kindly see the at page 47.
Page 47, yes.
Pursuant to the 1992 order, this 1993,
Yes.
it has been correction is done.
Correction, 200.
Then what you see out here is this,
Yes.
page 77.
Page 77, yes.
Pursuant thereto, they initiate to 18.
18.
See this notice.
Yes,
These are 18.3 notices.
yes.
Now, after these 18.3 notices, I think nothing happened, for which they filed the writ petition in the year 1993.
Yes,
And this is being disposed of with these directions. Kindly see 81.
yes,
The writ petition stands disposed of with a direction to the respondent to dispose of the sealing case number so and so pending before it.
yes.
Now, it is already disposed of. Because here the possession or no possession, handing over possession, these questions does not arise in a land sealing act.
Either there has to be surplus or no. That's it.
Unless they came up with a case out there that these, it could have been a case out there. That instead that this land is not proper now, you have given it to them, now they hand it over to us or give us some other land.
Yes,
That could have been given that this somebody is in occupation. That is not their case. So without that, I can't help you.
But this 93 civil rule, which your lordship will find in learned signatures past the order, we came here because they were not accepting the revenue from us. That's why we came up before this.
Which one?
Not today, this order. The order at page 81.
That is
passed by
nothing
the-
to say.
No, what I am saying, that was our case. The revenue they were not accepting. Till today, what I have been told by instructing council that today also they are accepting. the
Where is your
revenue.
statement in your petition? Saying that, where is your statement that you have not been able to pay the revenue? They have not handed it over. Why won't they take revenue?
No, that is not on record.
And
There
then,
is
then,
another
then don't
petition.
come up with all these things.
No. What is there? My lord, in person,
2433 of 1993, a writ petition was filed.
No, my question is, as of now, also you are saying that have encroached in view of the delay in arbitrary action in handing over the same for the purpose of the Indira Abhas Yojana, the same has been evident from the content of the report dated to so and so. The year says that when the owner of the land, it is the duty of the respondent to hand over the vacant possession of the land to the heir. The petitioner states that the petitioner company is paying revenue. Here you are saying different. Page 34, paragraph 34.
Para 34.
Para 34.
34, yes,
The
34.
petitioner states the petitioner is paying revenue to the on a regular basis and shall appear from the revenue receipt.
No,
So you are paying
thereafter they accepted the revenue. After that, they have started accepting the revenue.
from
After this writ, that is 2433 of 1993, after filing of the writ petition.
where have you mentioned that? That earlier it was not so.
This
Oh, this writ petition was filed by somebody else. Paragraph 28. Filed by A praying for quashing of the so and so. That the writ petition states that the petitioner greatly will be supposed to refer and rely upon the writ petition at the time of hearing. The Honorable Court was pleased to pass an order interior directing interim order of stay of the notice. That the writ petition of so and so was ultimately disposed of so and so, so and so. That so and so it was ultimately forwarded to the concerned authorities from the government, from the Honorable Court sometime in May. And company received a notice from the respondent intimating that they would appear before the respondent in purpose of attending the hearing. Also appearing in such a meeting that after the effort was the 13th time. Then what is this? Is unable to enjoy physical possession. Your possession, you have to take it by yourself, by operational, by civil court, not this.
that is there, but ultimately it is
You
their
did not
mistake.
come under 18.3.
I didn't come under 18.3.
Somebody else came.
Yes, but what they say, my lord, if 1993, that if a lordship looks into it, there's some type of eviction, they tried to settle that particular under 83. It didn't work out because they know that there are people who is there residing there.
No, they
So-
cannot. 18 could not have been resorted to.
No, what they have done, my lord, when they tried, that your lordship has looked into it, at page 77, on 2/8/1993,
Then these people came over.
but after the correction, when the correction was made on 24/5/1993, correction on page 47. So when correction was made, they tried because 77, if your lordship looks into it, that there was an order passed by SDO.
No,
The
in fact-
eviction
in fact,
process,
Page 77 is illegal.
I'm sorry,
Page 77 is illegal.
no, my lord, but the eviction process, somewhere eviction process, they try to carry out the eviction process.
Understood.
Because it was not possible to carry out the eviction process. So what they have done, subsequently, my lord, this order which has been put to challenge at page 95, where a lordship has looked at page 96, the operative portion of the order. Now they knew at that relevant time, when at page 77, they tried to carry out eviction. They knew that it is not possible to carry out the eviction because already they were encroachers. So very smartly enough at page 95, what they are saying, no. we
No,
have-
in fact, you should have at that point of time in 1990, at 1993, when this thing was done, this was done at your behest. You should have been more careful on this, should have known or consulted better lawyers.
Yeah.
Didn't you? Yeah. We dismiss your
Then
petition.
1993. Today we don't know, my lord, what is then, whether records of right, whether it is settled with those particular.
No, it is your name. Your name
No,
still
what-
appears. You are still
Yes.
paying the land revenue.
That's why, whether they are the settlement, I don't know, my lord, we
There
don't
couldn't
know.
have been a settlement because the land
will
is,
know.
the patta number is given to you of so and so. Yeah?
that whether they want the land encroachment fee, whether via media the government authorities by resorting to rule 18 or.
I'm very,
Consider by filing a civil.
therefore I say, page 77 was an illegal act on the part of the authority. Heard,
They
Mr.
suspect that result may have resulted in some extinguishment of their right. I cannot comment on it right now.
I would not. You want to withdraw? Instead of getting a dismissal, withdraw with a liberty to
Approach this civil court.
approach the civil court and the period during which this period is pending is.
That is better. That is,
Anyway, I won't allow you to withdraw. I'll dismiss it on the ground that I'm not entertaining and thereby grant.
liberty, the liberty to.
And the liberty is yours.
No, but even
I
that,
will only take care of 14.
yes, that's what.
Part of limitation. There was
That's why.
they are free to approach the civil court. There is no.
Anyways, adverse possession is also a thing that they have to recognize you as the owners.
Yes.
If they don't recognize you as the owner, then obviously it would not happen.
Yes.
There cannot be an adverse possession against a foreigner. Heard Mr. Dida, the learned senior counsel, assisted by Ms. N. Upadhyay, appearing on behalf of the petitioner. Petitioners, Mr. Arbo Pujari appears on behalf of the Revenue Department of the Government of Assam. Mr. B.J. Kalugai, the learned senior counsel, assisted by Mr. P. K. Medi, appears on behalf of the respondent number 2, 3, and 4. The present petition has been filed by the petitioner assailing the order dated (31/5/2013) passed by the additional deputy commissioner, Udalguri. The brief facts which led to the filing of the present petition are that a company in the name and style of Tejpur Tea Company Limited was the owner of a tea garden in the name and style of what is this tea garden name? Bahi Pukuri Tea Estate. Proceedings were initiated under the provisions of the Assam Fixation of Ceiling on Land Holdings Act 1956, for short, the Act of 1956. It is apparent from the order dated 5/5/1992, passed by the learned division bench of this court in Civil Rule number 4866/1991, that the petitioner, that the said Tejpur Tea Company Limited, who was the petitioner in the said proceedings, had no grievance as regards the orders passed under the Assam fixation against the final order passed under the Act of 1956. However, the grievance was that in the course of the proceedings, possession of 277 bighas, 2 kathas, 3 lechas of land was inadvertently shown as excess land. It further transpires that a representation was submitted by the petitioner by the state Tejpur Tejpur Tea Company Limited on 19/2/1990 before the Commissioner, Revenue Department, Government of Assam. On account of non-consideration of the said representation the said Tejpur Tea Company Limited approached this court by filing a writ petition which was registered and numbered at Civil Rule number 4866 of 1991. The said writ petition was disposed of by an order dated 5/5/1992 by the Learned Division Bench, thereby directing the concerned respondent authority to dispose of the said representation after giving an opportunity of hearing to the petitioners within a period of 4 months therefrom. The records further reveal that on 17/11/1992, the additional Deputy Commissioner Dorong Mongoldo disposed of the said representation in pursuance to the orders dated 5/5/1992, passed in Civil Rule number 4866 of 1991, wherein it was found that the tea garden, that the tea estate had handed over excess area of 216 bighas, 4 kathas, 5 lechas of land, and not 277 bighas, 2 kathas, 3 lechas of land, as contended by the Tejpur Tea Company Limited. Accordingly, the area of 216 bighas, 4 katha, 5 lechas of land covered by Dag number 8 of number 2 W/L Bahi Pukuri Bagicha was directed to be registered in favor of Bahi Pukuri Tea Estate and record of rights be corrected. The subdivisional officer civil Udalguri was directed to hand over the area covered by Dag number 8 and correct the records in favor of Bahi Pukuri Tea Estate. In pursuance thereto, the record of rights were corrected and the said area of land at measuring 216 bigha, today they have written it wrongly. Four kathas, 5 lechas of land were corrected and reflected in the record of rights by an order dated reflected in the record of rights as on 24/5/1993. The records further reveal that in pursuance thereto, steps were taken by the subdivisional officer C. Udalguri with the circle officer Majbat Revenue Circle to carry out eviction and hand over possession to the manager Bahi Pukuri Tea Estate and report to the office. The said acts, and at this stage, this case court may finds it relevant to observe that once the land had become the land belonging to a tea company, eviction proceedings could not have been resorted to by the revenue authorities on their own. As the same became entirely a civil proceedings outside the ambit of the revenue authorities. Be that as it may, in view of the communication issued by the subdivisional officer C. Udalguri, dated 22/8/1993, certain notices were issued under Rule 18(3) of the settlement rules framed under the Assam Land and Revenue Regulations 1886. The records further reveal that an organization, namely Pahipukuri Bagan Jana Kalyan Committee, filed a writ petition before this court, which was registered and numbered as Civil Rule number 2915/1993. It is also seen from paragraph number 28 and 29 of the writ petition that certain interim orders were passed staying the eviction proceedings. Be that as it may, by an order dated 12/2/2001, the Civil Rule number 2423/1993 was disposed of, thereby directing the respondent numbers 2, 3, and 4 to dispose of the sealing case, that is land sealing case number 12/7172, pending before it. At this stage, this court also finds it pertinent to observe that the said direction, pertinent to observe with great respect, that the said direction could not have been passed, inasmuch as the land sealing case number 12/71-72 already stood disposed of even prior to the order passed by the learned division bench of this court in Civil Rule number 2544/1992. Next. Be that as it may, in view of the directions passed in the order dated 12/12/2001, passed in Civil Rule number 2423/1993, the impugned order was passed on 31/3/2025, 31/5/2013, whereby the additional deputy commissioner Udalguri reiterated the order dated 17/11/1992, and further observed that the proceedings under Rule 18 of the settlement rules framed under the regulations could not have been initiated taking into account that the land in question was a private patta land of the petitioner company. It is under such circumstances the petitioner, being aggrieved, has approached this court by filing the present writ petition. This court have heard the learned counsel appearing on behalf of Mr. Gita as the learned senior counsel appearing on behalf of the petitioner submitted that when the land was taken by the respondent authorities as selling surplus, it was also the duty of the said respondent authorities to hand over the said land without any encumbrance the learned senior counsel submitted that in the meantime, the land having been shown as selling surplus, which was the excess, which was the land belonging to the petition. Various persons have already entered into possession and have raised construction. It was the duty of the respondent authorities, therefore, to hand over the possession of the said 216 bighas, 4 kathas, 5 letters of land, thereby granting proper possession with a clear possession, clear and unencumbered possession of any other person. The learned senior counsel further submitted that initially certain steps were being taken pursuant to the order dated 17/11/1992 to hand over the possession of the land in question. And in pursuance thereto, steps were taken under Rule 18(3) for handing over the possession for eviction, evicting those persons. The petitioner company had awaited the result of the directions so passed by the learned coordinate bench of this court in the order dated 12/12/2001, passed in Civil Rule number 2423/1993. And it was only after 13 years, 12 years thereafter, order was passed on 31/5/2013, whereby the respondent authorities have declined to exercise their jurisdiction under Rule 18 of the settlement rules. The learned senior counsel therefore submitted that immediately thereupon the petitioner had approached this court by filing the present petition. Mr. Arbor Pujari, appearing on behalf of the revenue authorities, on the other hand, contended that once the land that Rule 18, the exercise of jurisdiction under Rule 18 is limited to specified types of land which have been mentioned in Rule 18(1) of the settlement rules. As the land at measuring 216 bighas, 216 bighas and 16 letters. Became the property of the respondent authority of the petitioner company. These lands fell outside the scope of Rule 18(1) of the settlement rules. Therefore, the order dated 31/5/2013 passed by the additional deputy commissioner Udalguri do not call for any interference. The learned standing counsel appearing for the revenue department further submitted that the petitioners well knew in the year 1992 itself and subsequently in the year 1993 when the records were corrected that there was encroachment and it was the duty of the petitioners to take recourse to available remedies available under law. By way of a writ proceedings or by way of a writ proceeding, thereby insisting upon action to be taken under Rule 18. The present proceedings is nothing but an abuse of the process of the court. Anything more? I've heard the learned counsels appearing on behalf of the parties and have duly perused the materials on record. Rule 18 of the settlement rules refers to ejectment. Rule 18(2) stipulates the various forms of land. Wherein notice can be issued, wherein eviction proceedings can be initiated. The lands mentioned therein are government cast lands or wastelands or estate over which no person has acquired the right of proprietor, landholder or settlement holder, or any land that has been previously reserved for road or roadside lands or for grazing or village cattle or for other public purpose, or has entered into possession of land or in respect to lands which have been excluded by general or special orders. The records clearly reveal that Pursuant to the order passed by the learned division bench of this court, dated 5th of May 1992, in civil rule number so and so, 216 bighas, 4 katha, 5 lectures of land have been were corrected, covered by dag number 8 of number 2 WL Bahipukuri Bagisha was corrected and registered in the name of Bahipukuri Tea State. Any encroachment of the land thereupon by any other person and not a government authority by any other person becomes an interstate dispute between the petitioner and those persons. It is seen that in pursuance to the order passed by this court, dated 17/2/2025, the respondent number 6 to 58 have been respondent numbers 6 to 58 have been arraigned as parties who are said to be encroachers over the land belonging to the petitioner company. This interstate dispute between the petitioner and the respondent number 6 to 58 cannot be decided, or eviction proceedings cannot also be directed upon thereby authorizing the revenue authorities to take action, inasmuch as it is purely a civil dispute between the petitioner company and the respondent number 6 to 58. Considering the above, it is therefore the opinion of this court that order dated 13/5/2013, which is impugned in the 13 or 31, 31/5/2015, which have been impugned in the incident proceedings, appears to be is in accordance with the settled principles of law. That the revenue authorities cannot initiate proceedings under Rule 18 for eviction from lands other than the lands mentioned in Rule 18(2) of the settlement rules. Accordingly, this court does not find any ground to interfere with the order dated 31/5/2013, for which the petition stands dismissed. Before parting with the record, this court, however, duly takes note of that the petitioner, pursuant to the order dated 17/2/17, pursuant to the order dated 17/11/1992, have been taking effective steps before parting with the record, this court duly takes note of that by the order dated 17/11/1992, there was a specific direction upon the subdivisional officer C, Udalguri, to hand over the vacant possession of the land to the petitioners. The petitioners thereupon, steps were taken under Rule 18.3 of the settlement rules. An organization approached this court, assailing the eviction proceedings, and there was a direction passed by the learned coordinate bench of this court on 12/2/2001 in Civil Rule number 2423/2 1993. To decide the said sealing case within a period of 4 months. 12 years down the line, the impugn order has been passed, the impugn order was passed, and thereupon the petitioners have approached this court by filing the present writ petition. Taking into account that the petitioner have been bona fidely litigating before this court, presuming that this court would have the jurisdiction. However, as this court is not inclined to entertain the instant writ petition as it is an inter-se dispute between the petitioner and the private respondents number 6/58, it is the opinion of this court that the petitioner would be entitled to the benefit of Section 14 of the Limitation Act 1963 during the period when the instant writ petition has been pending. That is, with effect from (18/4/2018) till date. While computing the period of limitation in preferring any proceedings before the appropriate and competent civil court of jurisdiction, if so advised. Yes.
Well, in this case, well, the record from municipal board was called for that by RD order.
Who is paying for the board?
Some other locals appear lot. They have withdrawn the account number. Subsequently, the court directed us to inform the board about this case topic. Subsequently, we have made communication twice to us, but they did not give any account number.
Now they have not appeared. Malbari,
Honorable Minister.
you are appearing for? What is that? What has happened between you and him? From? And you?
My building is, my father constructed the building and holding was granted in 1969. And since then, my lord, I was paying taxes, municipal taxes, etc. And in 2009, my father expired, and thereafter, I, my lord, I applied for substitution of my name against that holding, my lord, holding number 6. And accordingly, certificate also was granted in favor of me that in my name has been substituted. But subsequently, an order was passed, my lord, by the municipal executive officer, my lord. Your lordship will find it is NSR 18, my lord. This- Page 51, my lord.
Yes, where?
Column,
Your name? Madan Kumar Chaudhary.
Sergeant Kumar Chaudhary.
Where is
Madan-
your name?
My lord, my father's name is Atmaram
Madan
Chaudhary.
Chaudhary, name of the
The
holding.
holding number 6.
Again holding Dharmaram Medhi. Who is he?
He is the private exponent here in this case.
The holding number 6 have been occupied by Atmaram shop house. Atmaram, but the plot of land occupied by the holding bearing number in the name of Nagarmal Khemka, which was transferred to Dharamram Medhi by a sale deed engineer. The official transfer is made by administrative order dated so. Then,
My lord,
where is the administrative order?
but that administrative order I was not provided.
Okay.
My
Then,
lord, that is why, my lord, the record was called for, my lord, whether in doing it, my lord, notice was granted as per section 863 or not. Section 83 of municipal act, my lord.
the holding is in your name,
Yes, my lord.
in your father's name.
Father's name, my lord.
So they changed it to the respondent number 4's name.
Yeah, respondent number 4 got a sale deed, my lord. In the sale deed, my lord, a Sali was transferred along with the land, my lord. No mention about the building, etc. my lord. According to them, now my building situated on that land, my lord.
What is your building? RCC house, ground floor,
RCC building.
RCC building, ground floor, 2 rooms, first floor, 2 rooms, and open. Isn't it?
Yes.
Open portion is 38. So assessment value is so and so. So this has happened in 1979 and this was corrected in 2009.
9.
And you came in 2018.
18, my lord. After
9 years.
After 9 years, my lord, I pursued the authority for long time, my lord, to provide me the assessment or assessment order, etc. And the order passed again in favor of them.
Then also you wouldn't get it.
Yes.
When did you first inform?
I was not provided, my lord.
Recently, when I approached to Nalbari Municipal, I was let to know that my name has been struck off from the holding number 6 and someone's name has been included in the same holding.
In 2011.
That this is abruptly legal since no name can be changed in respect of the standing petition and against the existing utility to continue for a year. Further, without notice to me for change. In 2011. Then
After that,
after 11, then what?
then I submitted.
Then you approached in 2018.
Yes.
Why? How did you construct?
My lord.
How did you construct? Yeah, how did you have your name mentioned in the holding?
My lord, in 1969, it was assessed, my lord.
How?
My lord,
That is not your land.
that is my father's brother-in-law's land, my lord. I was allowed, my lord, as my father said, my lord, that it was granted on lease.
Civil suit.
Civil suit, my lord, my lord,
Go to civil court.
they will go to civil court, my lord.
You go.
My
You,
holding,
why should we entertain?
my holding is there, my lord, in respect of my building, my lord.
So
And
what?
as per what should I find the section 83 of the.
Not section 83 would not. You gave a representation in 2011. Thereafter, why have you approached in 2018?
It is correct, my lord. I am late.
Civil suit.
My lord,
So first of all, you have to show me that how did you have your name?
my lord,
I may be given some time and I will have instruction to that extent regarding this. How, yes, madam?
And the registered owner shall purchase by registered sale in the year 1998.
Who, you,
Based on the
98.
98. Originally, there are 16 results of.
Let's see your sale deed.
They have annexed this. Page 39A.
Now, this sale deed shows about one old Teen Sally house on the
Yes.
holding number 7.
Actually, there are total 16 lesser of land, that original owner. He sold me 7 lesser and 9 lesser to some other person. That sale deed also there.
No, but yours is 7 letter.
Only 7 lesser.
This is under holding number 7. But in holding number 6, why your name has been inserted? In both the holdings, why you have been sold 2 properties?
We have sold 2
No. There are 2 sale deeds. No. Yes.
One in favor of me and one in favor of another.
This is regarding others, my lord.
No, yours, you have been sold. Nagarmal Khemka sold it to Dharma Ram Medhi. That is holding number 7.
Yes.
Okay. Now, what about holding number 6? That is 8 letters of land. Where is that sale?
Holding number 6 is belong to me, man.
Huh? This is holding number 4. Sale deed.
Yes, sir, and this honorable could directed to produce the record loss.
No, my question is this. Are you showing, there are 2 sale deeds. One is of 2004, one is of 1998. 98 is in respect of holding number 7. 2004 is in respect to holding number 4. How did you get your name in holding number 6?
Holding 4 sale deed is not good. I only in respect of.
No, there are, no, kindly see page 39A.
Yes, sir. This is
That
my
is
sale.
your sale deed.
This is my sale deed annexed by the application.
Okay, so there is holding number 7 or
7.
holding number 6?
Holding number 7.
7.
Then why the name was inserted in holding number 6?
In fact, holding number 7 also my name is inserted.
Very well. I'm not on holding number 7.
Yes.
He's also not on holding number 7. He's only on holding number 6. Why your name was inserted on? You were not sold anything. Then we set aside this. Over. Not over.
It's a record.
No, not record. My question is this. Why your name is there in holding number 6? Sale deed says 7. 7, your name is already there. And you have purchased only 1. So your name is there in 7.
In fact, he has challenged the order of the holding number, transferring the holding number in respect of 6 lordship.
So therefore he is only in 6.
No, lordship. Yes,
Yes.
only 6.
He's on 6.
Yes.
He's only asking for 6.
6.
6 holding number was already there. That how can he be a sale deed of 1998? The 98 sale deed is only in respect of holding number 7. So therefore, we set aside this. Therefore, you see it is XLA room. That is what has been sold to you.
That is good.
We allow your reputation.
Otherwise, delay ground is there also.
Not necessary. Not necessary. Your name could not have been inserted here because you never purchased this.
I have purchased the land in holding number 7.
7. So 7 is there. We don't require the Nalbari Municipal Board, but we impose a cost upon the Nalbari Municipal Board to be taken from the chairman around 50,000 and then deposited to the DLSA and to be recovered by the deputy commissioner for not providing the reports. In spite of you, we take it up. Don't worry. This I know how to tackle with these. Not only set aside this, then they will. Here again, holding number is 310. Why?
310, that is earlier originally. Subsequently, it has become 6 million, or ward number 6. In 1969, it was 310. I have a next melody, next one.
So we impose the cost on the chairman, not by the municipal board. Heard Mr. D. Chaudhary, the land council carrying on behalf of the petitioner. Miss. So and so, and Goswami appears on behalf of the respondent number 1. And so appears for the respondent number 4. None appears for the respondent number 2 and 3. Before taking up the instant proceeding for disposal, this court finds it very relevant to take note of the conduct of the respondent number 2 and 3, which is a municipal board formed under the provisions of the Assam Municipal Act 1956. The said respondent number 2 and 3 initially had appeared before this court. Subsequently, they chose not to appear. The records further reveal that on 23/2/2026, the learned coordinate bench of this court was of the opinion that a response from the respondent number 2 and 3 are required. And further, it was also opined by the learned coordinate bench that if the response is not filed, at least the records pertaining to the subject matter be produced before this court. The records further reveal that the learned junior government advocates, Mr. N. Goswami, as well as Mr. N. Das, on various occasions have written communications to the chairman, Nalbari Municipal Board, along with the copy of the order dated 23/2/2026 for producing the records. However, in spite of receiving those communications, the respondent number 2 and 3 have not chosen to either file the response or even produce the records. This appears to be the said action on the part of the respondent number 2 and 3. We initiate suo motu proceeding for contempt against them. Better. This one. Respondent number 2 and 3 appears to be in direct contravention to the directions passed by this court in the order dated 23/2/2026. Taking into account that the interference is being caused to the administration of justice, this court imposes a cost of rupees 50,000 upon the chairman of the Nalbari Municipal Board. The said amount be deposited by the chairman of the Nalbari Municipal Board before the registry of this court on or before 3rd of September 2026. Next. The present petition has been filed by the petitioner challenging the action on the part of the respondent number 2 and 3 in deleting the name of the petitioner and recording the name of the respondent number 4 on the basis of a deed of sale bearing deed number 2897/1998. It is relevant to take note of that from the records, from the materials on record, it is apparent that the petitioner's father name was duly recorded against holding number 310 of the Nalbari Municipal Board. The said holding thereupon was renumbered as holding number 6, as would be apparent from the various municipal receipts enclosed to the petition. It is further relevant also to mention that from the extract of the municipal register, which is Annexure 18 to the petition, it is seen that holding number 6 was in respect of an area of land at measuring 8 lechas, wherein the name of the owner of the holding was put as that of the father of the petitioner, and the present owner of the holding has been put and the present and the respondent number 4 has been shown as the present owner of the holding. It is also seen that the description of the holding number 6 have been also mentioned in the extract of the municipal register to be a shop house, which is an RCC building of ground floor 67 square meters, 2 rooms, first floor 2 rooms 67 square meters, and open portion 38 square meters. So it is also very relevant to take note of holding number 7, wherein also the name of the owner of the holding has been mentioned as one Nagarmal Khemka, and the respondent number 4's name has been shown as the present owner of the holding. It is also seen from a perusal of the extract of the municipal records, municipal register, that holding number 7 is an actually 1 room, floor area covered to be 40 square meters, is equals to ACSR W/S/W/D, 3-sided W/W, and 1 side P/D dot P/P, and so on. Page 51 of the as well. Describe the description of house is as here. It is also seen from the said municipal extract of the municipal register that the transfer has been made in favor of the respondent number 4 in respect of holding number 6 and holding number 7 on the basis of a registered deed of sale bearing deed number 2897/1998, dated 25/2/1999. The records further reveal that the said sale deed dated 28, the said sale deed dated the bearing number 2897/1998 have been enclosed as annexure 13 to the writ petition. A perusal of the said sale deed, which have been sold by one Nagarmal Khemka in favor of the respondent number 4, clearly shows that a plot of land at measuring 7 letters, bracket 0.95 R, along with an old tin chali under holding number 7 of being covered by dag number 1011 of KP Patra number 114 of ward number 1 of Nolbari town near Nagara Chowk, bound by North Road, South, South, East Annapurna Tea Company West Road, was sold to the respondent number 4. The said sale deed had no relevance to the land or the holding, the land and the holding standing thereupon, and holding number 6 standing thereupon. Under such circumstances, the mutation so carried out in favor of the respondent number 4 in respect to the holding number 6 by the respondent number 2 and 3 was clearly an act, or was clearly illegal and unauthorized. It is also seen that the petitioner had categorically alleged that no notice was issued to the petitioner as required under Rule Section 83 of the Assam Municipal Act 1956. And the said notice have not, and the said aspect have not been denied by the respondent authorities. Considering the above, it is therefore the opinion of this court that the impugned recording of the name of the respondent number 4 as the present owner of holding number 6 is by the respondent number 2 and 3 is illegal and unauthorized. Accordingly, the writ petition stands disposed of with the following observations and directions. Number 1, the order by which the name of the respondent number 4 was inserted against holding number 6 of Nolbari Municipal Board, ward number 1, na? Ward number?
Ward number 1.
Ward number 1.
Ward number 2, man.
Ward number 2. Roman 2.
No, man. Nimal. Ward number 2.
Ward number 2. Ward number 2 of
Number
is set aside and quashed. Number 2. The respondent number 2 and 3 are directed to take effective steps for recording of the name of the petitioner, who is the son of late Atmaram Chaudhary, against holding number 6 of ward number 2 of Nalbari Municipal Board. Number 3. The respondent number 2 and 3 are directed to deposit the amount of rupees 50,000 before the registry of this court on or before 3rd of September 2026. This court further directs that in the circumstance the said amount is not deposited by the respondent number 2 and 3 before the registry of this court, the registry shall immediately pursue the matter with the Bakijai officer of the Nalbari, Bakijai officer Nalbari, to recover the said amount from the respondent number 2 and 3 as areas of land revenue. Number, it is further observed, this court further directs that upon the deposit of the amount of rupees 50,000 by the respondent number 2 and 3, which is being as directed above, comma, the registry shall transfer the amount to the Assam State Legal Services Authority, the Assam State Legal Services Authority thereupon shall remit the said amount to the Punapur Old Age Government Home, Old Age Home ne kiba tha asylum, so that the same can be used for the benefit of the said party. So respond number 1. To the respond number 3. Are you asking money?
Oh, the lordship, because the respondent number 3 has imposed the penalty that of rupees 1,55,000 because of the late receiving of the IAGN number. The respondents have, respondent 2 and 3 have filed the affidavit. In the affidavit, it is clearly stated because the fault is on the part of the airline in providing the IAG number, not because of the respondent number 2 and then accordingly on the last date I have amended, I have made the airline as the party in this suit, lordship. That is 5, 6 and 7. The lordship comes to the affidavit filed by the
No, it is a recovery against them. Why should we exercise jurisdiction here? Tell me why.
because on the lordship come to the affidavit filed by the respondent.
I've looked into it.
That they have clearly stated the delay is in the part of the airline.
In your representation also, you say that the airline have wrongly given it.
Ah.
Okay. Now, why you are asking the money from the respondent number 3? It is not the fault of the respondent number 3.
Yeah, thereafter, we have subsequently made the airline of the party.
Making a party is not of use. With your, you have not asked for that. You have not amended your petition.
Yes, I have amended.
You have amended the petition.
I have filed the amended post title.
Post title is different.
Yes.
Amended the writ petition or not, then. And this is the case which you should go before the consumer forum or do or whatever may be. This is not the case by which we are going to do it. As to whether it was whose fault or not, how can we decide? Go before the consumer forum or before the civil court. This is not the court.
Let the airline appear and file affidavit.
Has airline been issued notice?
Yes,
Huh?
sir. I have issued notice to the RBI.
Has airline been issued notice?
I have taken steps on the airline.
But there is no allegation against them. In view of the revelations and in the affidavit filed by respondent number 2 and 3, don't you think that the allegation has now to be against Air India?
Yes.
Then your entire repetition is on a different thing only. Your representation where you have submitted. You clearly see I have submitted the bill of entry lately because of which the customs had imposed penalty on my bill of entry. And this has been given by Air India to you later. Then
Because lots of on the same ground, my even respondent number 4 have also imposed damage charges. Therefore, after filed the representation for them, on the same ground, they have waived off my penalty.
respondent number 4 is okay. I'm not on that. But here there was a delay, admittedly. So you are asking for compensation.
No, not compensation, only the damage, the penalty charge.
It is a form of a compensation. You see the penalty which you need to pay if you delay. Isn't it? Now, this penalty, you say that I should not be liable to pay. Delay was on account of Air India. And if it was for Air India's delay, then why should I be at fault? So that amount should be refunded back to me by Air India, isn't it? But where's your prayer? Where's your petition in that manner?
I'll amend it.
What amend it again? What remains in this petition there? 2018, you're making amendment after amendment and now. And what about the notice about response number 5 and 6?
What you have taken steps today on
What?
the respondent.
You have taken notice steps today.
Yes.
Notice was issued in the year 2025. You have taken steps today. You are not interested in. I don't think we should entertain this.
What's it, only 2 weeks may be given.
No, nothing doing. What is all this thing? Your petition cannot be given.
Only 1 week time.
No, you have rendered this court into the civil proceed, the civil court. Go before the civil court or a consumer court. Have not taken notice of the It is saying that the notice was issued by this court upon the newly implemented respondent number 5, 6, and 7 on 23/7/2025. But till date, no steps have been taken. It therefore appears that the petitioner is not interested in pursuing with the present proceedings. Accordingly, list this matter only upon completion of steps service upon the respondent number 5, 6, and 7.
2 weeks, 1 week. Like,
Please, your lordship.
Oh, morning.
Yes, lordship.
Yes, what has happened? What is your matter about?
Lordship, I have gone through the second file
Ah,
because Mr. RD is, has, made,
what are you challenging? Let me see.
there are two grounds, lordship.
Clearing
One,
proceeding pending before the forensic arbitrary setting inside and washing. Yes. Yes.
yes, lordship.
Two ground.
Violation of section 10 of Bengal Public Demands Recovery Act 1913, and secondly, time bar of recovery. So I have gone through the second side. So lordship, I am not so much clear about it, but what I am understood.
It's okay.
He
Do
had
you
got
know the
8
case or
stitches.
not?
Lordship, he had got 8 stitches and he can't able to walk also.
Madam, didn't I give you an assurance? If the repetition can be allowed, I'll allow it. But if I have to dismiss it, then I would adjourn it. Isn't it? Don't worry. You have come before this court today knowing fully well it is a no one. Okay? So now you cannot get out. Okay? Yes. What is it? Respond number 4.
then, what is on the,
What is it?
we are collecting. Intention is that agent it is not maintained, it is not part by limitation. Then it has filed case in 2018. The last transaction is made on 2016. Inevitably, I impose the said even deposit slip. On the other hand, this is the public money he borrowed from our bank. So due to non-payment of debt, we take recovery proceeding under Bengal Public Demand Recovery Act. Under recovery proceeding, he denied his liability on the ground that it is barred by limitation. So I also enclose a statement of account in my affidavit of opposition.
Now tell me one thing. Can in a recovery proceeding before the Pakija officer, point of limitation be decided by the Pakija officer?
We have filed within period of limit. And Bakija proceeding is taken within period of 3 years. Standard
Now,
limitation
my
period is
question
3
is,
years.
the petitioner have taken a ground of limitation. Can the limitation aspect be decided in a Pakija proceeding? The question is that. If it cannot be decided by the Bakija officer, then obviously the repetition is maintainable. It's a different thing that she may not have a case. It is not barred by limitation. Then it's a different aspect of the matter, which I can very well say that it is not barred by limitation and thereupon the proceedings can continue. The question is the repetition is otherwise maintainable. Because if the Bakija officer cannot decide on the question of limitation. Okay. Now let us see why it is saying that it is barred by limitation. The show cause notice, let us see the show cause notice. Lecture C.
They filed a show cause notice, lordship. Then after we have replied physically, they have not accepted. After that, we have registered.
Wait. Reply to the Bakija area. Certificate was appropriately issued. Petitioner of financial Will you come to paragraph 4 of your affidavit? That the answering the respondent begs to state as per the record statement, petitioner made deposit of rupee 20,000 on so and so. 18, 10, 16. And petitioner also requested for compromise settlement of the account. Loan account in writing on so and so. And the suit that is there was filed on so and therefore was within the period of limitation. Now, where is the compromise petition? Kindly see limiter. See. Okay. Litera 98. Page 90. Page number equal one. This is annex 3 of my affidavit. Now tell me one thing. Have you taken into consideration that 20,000 which he has deposited?
Yes, yes. From that, if it is counted from the last date deposit of 18, 10, 16.
No, my question is not on that. My question is, while calculating his amount of 7,33,000, have you calculated the minus, deducted the 20,000? If you have not deducted the 20,000, then there is no acceptance of that amount from them.
In my knowledge, if the account is declared NPA, thereafter any transaction made by the parties, it should not be maintained in the original account. It's a separate account.
So how are you putting a requisition for the additional amount of rupees? You see, your amount initially was 6,60,000. Thereupon, that was in 2014. Then at that point of time, he said that kindly take care of my two FDs, 90,000, these two FDs, you kindly take it over. And thereupon, did you take those two FDs?
If I have not gone through the interest, but so far as the submission is that once the accounts of two parties declared NPA, in that case, bank should not made any transaction in the main account.
So that means how can you increase the interest? If you have declared it to be an NPA in 1990, in 2014, there cannot be an interest also. For the purpose of recovery, you may. For outside everything, you may. But the moment you are imposing the interest and making it 7,25,000 at a later point of time in 2018, you are imposing an interest. How are you putting an interest on an NPA account?
When the account was input, because in the
No, this letter is there now. You don't deny to this document. Kindly see this document. Kindly see Annexure A, page 18 of the writ petition. So it has been categorized as NPA on 39/2014. That is 6 lakhs. Okay. 6,56,000. Okay. Then how did it become later on 7,33,000? If it is NPA. One. And number two is, did you accept that, take into account the 20,000? You are banking on that on 18/10/2016, he has deposited 20,000. And thereupon, he has given a one-time settlement offer. So it is an acknowledgement of the debt. That is what you are trying to say. But did you go into that part payment of 20,000 which is being made and put it inside? If you have not, then can you say that this is a part of it? If you have kept it aside, the 20,000, can you say that section 18 of the Limitation Act will come in?
Is that if any borrower account classified as NPA, if you do not make transaction for last 90 days, in that case, bank classified as the account as NPA. After account classified as NPA, the bank charge interest or any transaction made by the borrower in separate account. As soon as the account is regularized, the main account.
So therefore, just for example, you have asked 6 lakhs, 6 lakh 50. He has paid you, let us say example, 6 lakhs he has paid. 56 remains. Otherwise, 56 remains. But in view of the NPA, you keep it as NPA. You have not got it. So you have not adjusted that amount.
Whatever amount paid by the borrower, it is accepted by bank. It will be adjusted when the entire account will be closed from that total claim on the state deposit. Before NPA, after NPA, all will be adjusted. As soon as NPA is declared, bank cannot adjust. When if the entire amount is paid, in that case, NPA will be lifted. Until and unless NPA is.
So if it is an NPA, you cannot touch on the bank account. Then within the limitation, would anything else or writing out the letters out there would condone with the limitation?
Of the petitioner.
That is what they is saying. They say that in 39/2024, 14 you have made us NPA. Means for last 3 months I have failed to deposit my installments. That is what he is saying.
Yes.
So thereafter he says that you initiated an action in 2018 and therefore 4 years have gone by. Can you do so?
Your Honor, he has deposited another payment in 16. If
That
any,
is what I am saying. Whether you have appropriated that and made it a part of it. You see, any
Yes.
payment is being made against that amount or an acknowledgement in writing in respect to. He does not acknowledge. He says that he is only giving you an offer. That look here, I'm going to pay you 2 lakhs as an out of court settlement, as a full and final settlement. I don't acknowledge anything. Only 2 lakhs I'm paying. Out of that 2 lakhs, only 20,000 is the remaining 20,000 I paid. 1,80,000. If you accept, I can pay within such and such day. Tell.
20,000, my lord, yes, a bank has accepted.
So therefore, my question is, you can't accept to the 20,000 unless you have accepted the 2 lakhs. Did you accept the 2 lakhs as a one-time settlement? Because 20,000 was a one-time settlement. A part of the one-time settlement.
Usually, borrower offer an amount and initially it will be a part amount. Until unless said proposal is accepted with the bank, he cannot pay the entire amount. Suppose if a borrower proposed for 2 lakhs.
2 lakhs to 20,000 was a part of his one-time settlement.
Part of one settlement.
That is your document in 2017. 20,000 was a part of the settlement. He says that I pay you 20,000 and remaining 1,80,000 I pay subject to. He does not acknowledge the 6 lakhs. He acknowledges 6 lakhs in the year 2014. So therefore, the question is, isn't it beyond the period of limitation?
In this case, petitioner deposited in 2016, 20,000.
Again, I'm saying that.
And we take.
Mr. Counsel, kindly see your affidavit. Kindly see your affidavit. Why I'm saying so. I'm not saying otherwise. Kindly come to page 111. In view of the above, presently I am not in a position to repay the loan amount to the depositing monthly return in any cash credit account. However, I am ready to pay an amount of rupees 2 lakhs as a full and final settlement of the entire outstanding amount up to date by interest lying in my aforesaid account. I have already tendered an amount of rupees 20,000 on so and so being 10% of the total settlement amount, of which 2 lakhs. In case of your acceptance of my alia, I shall pay within 3 monthly installments. This is his one-time offer. Then this happened in 2017. You didn't accept this. You don't record the acceptance of this 20,000 against that loan. So therefore, how can you say? Now, in view of a recent Supreme Court judgment, it says if a part payment is paid, not acknowledging the entire amount, then there is nothing out there. Limitation goes.
And maybe to
What?
clarify this point,
What is there to clarify?
not to confirm the payment. Okay, lordship, permit, I may confirm from the.
Huh?
What is they are saying, I may be allowed to confirm.
Then this is your document is a dangerous document for yourself.
Petitioner contention is that our case is part by regulation that we should not claim any amount. Our contention is that we should file in 2018.
Understood?
Last deposit is made in 16.
It is not a suit. It's a recovery.
But it is.
There's a difference. You are going for recovery.
Yes, but it is-
Recovery, when you have made it NPA in 2014, can you go for recovery in 2018? That is the issue.
After declaring NPA, petitioner time and again approves to our bank on when ground that account may be settled shortly, I give some time.
And they'll be.
He has not paid the dues. In time.
Obviously, he has not paid the due,
In
and he
time.
doesn't want to
That
pay
is
the
the
dues.
compared to take repossession. The payment we made, we are not denying it. But full payment is not made as mentioned in the. Is a part payment.
That 20,000 you have entered, look here, page 141. That is what I was telling you. See this. Not read your file properly, Mr. Counsel. The third deposit, 141. Good. But this 20,000 is there. Therefore, you reach at 7 lakh to 25,000.
That amount, when he deposited at that time, he has not submitted the receipt for compromise program. This is deposited in 16. Proposal is given in 18 after 2 years. In the said letter, he mentioning about his deposit, which he made 2 years ago, that should be treated as the part payment of the complaint. Usually, proposal when made at the time, some initial amount to be paid.
Now, whether a part payment being made, could that be acknowledgement of the debt?
Well,
Would the timer start to run again?
Petitioner deposited 20,000 on
No,
2000.
Mr. Counsel, whether payment of a part payment of 20,000 would amount to acknowledgement of the debt?
Yes.
Where? Show me the law in that regard.
My lord, petitioner deposited 20,000 on.
You say that interest. Now you see, therefore, although you have put it as NPA, but you are putting against interest. You are claiming interest. Look here. Page 141. All these are interest. How are you doing it?
On the balance amount. On the balance amount.
Then
Interest is charging on the balance amount.
the last 2,000 rupees he has paid here you see. You have adjusted these amounts against the fixed deposits in 2014. See these two amounts, 1,21,000, 1,11,000. Page 139. There? Madam, you get that judgment of Justice
Yes,
Party
sir.
one recently given.
Yes, sir.
Take it out, then finish it off. Oh. We should set aside, wash. Okay, you appear, but your senior appears, you know what is going to happen. When can you get that judgment?
Today I'll search Lordship.
You search. Yes, it was given, I think, February 2026. Look into section 19, 18, 19 of Limitation Act. On the question of acknowledgement. Okay.
Yes, sir.
This court have heard the learned counsels appearing on behalf of the parties on the question of limitation for initiation of Baki type proceedings, more particularly taking into account that on 30/9/2014, the petitioner's account have been classified as an NPA, whereas initiation of proceeding before the Bakida officer was done sometime in the year 2018. The learned counsel appearing on behalf of the petitioner submits that she will place before this court relevant authorities pertaining to Section 19 of the Limitation Act 1963 and submitted that these authorities would clearly show that man making a payment of rupees 20,000 during the currency of the period would not amount to an acknowledgement of the liability, thereby extending the period of limitation by birth. Limitation. When this matter again on? Before your senior recovers.
After 1 week,
But then there is no ball, huh?
after 1 week.
This matter again on 31st of July 2026.
Right.
Yes, Mr. Seshia?
Some amount amounting to more than 4 lakhs were withdrawn by somebody. And it has been informed to the bank several times. Then the ombudsman Malad issued a letter to me for conciliation. And the conciliation was held, Malad. At page 39, in short and short, Malad. At page 39, Lordship. Banking Ombudsman of Reserve Bank of India.
Yes, what has happened? In the ombudsman, what has happened?
Malad, at page.
Well, the ombudsman, a decision was taken that the matter would be referred to the authority of the competent authority of the bank to take the decision, because the assistant manager who has appeared, he did not have that financial power to allow. And so the competent authority took the decision, my lord. In my affidavit in opposition, I page 68, my lord. Page 68. In terms of page 68, then
So this has been taken. In view of the above, we
Yes.
propose to treat the incident of transaction as fraud and accordingly recommend for restoration of the disputed amount.
yes.
Then,
Now your lord, my lord, may come to page 73. In fact, this ought to have been started from page 74. Page 74, my lord.
Page 70,
74. my lord. It's the
70.
flipping of the page.
24.
Yes, my lord. In the page 74, in the column, tabular form, last column, lordship, may kindly see, amount recovery write-off. So rupees 69,023 was approved for restoration. The remaining amount of rupees so and so, which took place after the complainant noticed the discrepancy on 12/3/17, was rejected, as the complainant was negligent in not blocking the card or bringing it to the notice of the bank.
On 24, 2017.
He has, for the first time on 24/4/17, he lodged the FIR as well as made the formal complaint before the branch. And so in that circumstance, my lord, may I take the lordship to page 26 of the writ petition. Page 26, page 25 and 26.
Page 20.
25 of the writ petition, my lord.
When did he lodge the FIR? 24.
24/4/2017. And the formal complaint was also made before the branch, concerned branch on 24/4/17. And on the very same day, his ATM was.
Let us see the
blocked.
bank account details.
I am coming. My lord, before that, we'll read this page 25. Just a
Page
small,
20.
page 25 of the writ petition, my lord. I would like to inform you that I, Niren Chandranath, an employee of Kendriya Vidyalaya Sangathan since so and so, myself a customer for your funds since May 2013. By SBI account number so and so, ATM card number so and so. Sir, on 12/3/2017, I was attended ATM to withdraw some money from my account, but I could not withdraw the money from ATM and I received a message from ATM. Sorry, unable to process. Contact your branch. Due to overload of official works in the month of March, I was unable to contact your branch in time and I had come to know that my ATM is blocked. But I checked the balance on that day that it was above 3 lakhs. Then I was doubt about the balance in my savings account. In spite of that, I was not appeared to your branch due to my official burden and was not sure that the balance of rupees so and so each saved as my ATM is blocked. So now I have come to know that my bank account number so and so and ATM has been hacked by someone since January 17 or after January. Due to my casual attitude, this matter has been happening. He has very much knowledge on 12/3/17. And he approached the bank on time, my lord. Subsequent transaction could have been avoided.
Mr. Produce the bank account details.
Yes, it is there, my lord.
Yeah.
Yes. Petitions. My lord will find a page.
The Reserve Bank, the party.
No, my lord. No. In my affidavit in the position, I filed the bank account reports, statement of accounts. S75 onwards.
Why the Reserve Bank has not been made a party? Mr.
My lord, the Reserve Bank, my lord, I have not come against him because the
Aha. Mr. You have to understand. Certain things from where Reserve Bank has to be made a party because Reserve Bank has issued a direction upon them.
my lord,
When you see this particular document, this is very relevant. Kindly see page 43.
page 39,
Page 43,
my lord.
bank version.
Yes, my lord.
bank's version.
What's it?
The bank version says that they have investigated the matter and the disputed transactions have been considered as fraudulent. The branch has recommended restoration of the disputed amount of AR to the customer's account. The amount will be restored and after approval by the IVA, conciliation proceeding. The banking ombudsman held a meeting on so and so of the PA. Your problem has been amicably resolved by the bank and in view of this, it has been decided to close the complaint in view of so and so of the IMAN, settlement IMAN, by order of the banking ombudsman. Now this is it. It has happened. This is given by the Reserve Bank.
Yes, ma'am.
To make the Reserve Bank a party. See, the thing is like this. If you were 25 or 30 years old, I would have thought it differently. But you are 61 years. You sometimes what happens, you are counsel, the thing is like this. If you go out there for a person who is 61 who is not doing with the ATM and all these things, when they get it becomes very difficult for them to go ahead and do anything else. It's a difficulty to the effect that, but they are sure one thing, that if my card is blocked, how can anybody siphon off any money? It is never thought of for them. But the fact remains that somebody has done it. He has not been able to operate the bank. The fact that he would have seen the bank while he is receiving his messages. Now the important thing is, where you receiving those messages? Your account, the moment you are having a bank account with the SBI, your mobile number must have been given. So if there is any deduction, any amount being taken, what way were you doing and all this while? So these things all need to be answered. But anyways, I think you should make the Reserve Bank a party. If you make Reserve Bank a party, then the things should be different because this is how the Reserve Bank dispose of the matter. See, that's me passing a direction in this manner here may have a lot of implications. If the Reserve Bank does it, it's on a different aspect. Because here it will open floodgates. This is a very serious issue. So, but if the Reserve Bank on the basis of this, if it is done, it's a different aspect. There are many aspects which needs to be looked into. So Mr. Yeah, I think you make the
I will make a party.
Reserve Bank a party. Okay.
But only on submission matter. I will make them party. On the date of conciliation, they agree. They themselves were present. That page 41, the original copy. Their manager was present.
The note was made by the.
They themselves were present. That page 41. This is the original copy. And
It's okay. You make the Reserve Bank a party.
I will make it. I'm obliged to, so I will make it.
Mr. R.C. Sakia, the learned senior counsel, assisted by so and so, submits that the petition that the Reserve Bank, the Reserve Bank of India should be made a necessary party. Is a necessary party to the instant proceedings, taking into account that there was a decision taken under the aegis of the Reserve Bank of India about restoration of the total amount of rupees 4,13,000. Taking into account the above, he submits that the petitioner would like to file an application seeking to impede the Reserve Bank of India as a party. List this matter upon such application was made.
Obliged.
It is the office of the banking ombudsman, the Reserve Bank of India building. That
Down
the
below,
decision is of the,
filing the see page 43.
that is this guideline
That is a different.
of the.
Thing is that we can put the pressure through Reserve Bank to you.
Right.
But if I direct you, it will have a lot of consequences. That is the thing which is very difficult. Yes, another bank. What is the bank has to do?
Number 10 is an RS infra.
And I just take 3 days time to file my affidavit in opposition.
What?
My lord, here the
Because on
petitioner
16,
husband died.
Wait. That's phone number
$10.
RS Infra. What is this matter about?
My lord, here the petitioners are praying for ex gratia, my lord. The petitioner number one husband died due to electrocution, my lord. The petitioner.
You too?
Electrocution, sorry,
Electrocution.
my lord.
Okay.
While the petitioner number one husband was a daily wage laborer, he was employed by this number 5 and 6 to paint the high railway high gate. And then on the fatal day, he was died due to electrocution, my lord. This is the case about. And on
You were an employee?
no, I'm daily wage laborer.
Huh?
Engaged daily wage laborer, my lord.
Were you not entitled under the Workmen Compensation Act?
I mean,
There you may get more money? No? Anyways, you want what? Time
Mr.
for
Lordship,
filing?
Yes, 3 days time to file my affidavit in opposition.
How
my
much
lord,
time?
last two occasions they have been taking time to
Oh,
find.
don't worry.
I know.
I'm sitting here for some time. He cannot later on. I remember. No further.
Otherwise-
Mr. So-and-so appearing on behalf of the respondent number 10
Yes, sir.
submits that a final opportunity may be granted to file the affidavit in opposition. It is duly taken note of that on the earlier occasions also, time have been sought for by on behalf of the respondent number 10. Was taking into account that the instant repetition has been pending for the last 5 years, Mr. M. Sharma submits that the affidavit on behalf of the respondent number 10 will be filed without fail on or before 17th of July 2026. Lists the matter on 20. Wait, let's have it on 24th.
Well, I'll be out of station on the day.
You are there?
I'll be out of station.
Okay, 20.
In the my lord.
No, no, sir. Can it be on 21st? Can it be on 21st?
No. Why?
But I have some other matters in.
21st is not sorry, it's a small matter. On 27th. On 27/7/2026, in the meantime, the petitioner would be at liberty to file reply to the affidavit filed by respondent number 10.
My lord, 22nd, 22nd, 22nd.
27.
I'll be out of station, my lord.
Why?
For medical ground, my lord.
Oh,
I want prior to 20. Prior to.
no, we can't. On 31st.
Well, I'll be out of station for 2 weeks. I'll be going to Bangalore for my medical books.
Okay. Then you file your affidavit by 31st. And the final opportunity is granted to file the affidavit by 31st. List this matter again on 10th of August 2026. Reply. Yes, what is this?
Settlement of land order was passed in my favor way back in 2015.
Yes. What is your instruction?
According to the 1989 land policy lordship, possession is required lordship. After allotment lordship, 3 years continuous possession is necessary lordship.
Why you are going into the 89 policy when we are talking about in 2019?
Lordship,
No, no.
allotment was
Now, are you now trying to say, where about that?
allotment
Allotment made in 2015,
No,
it's
sir.
okay. I'm not on that, but
No,
as of now, it has to be done as per 2019.
lordship.
So now you don't require it. How does it matter if he is there in 2000? You want You are going to grant an allotment in tag number 360, but he is in possession in tag number 259.
No, 360.
He is in 360. Then why you are not granting it?
He's not in a possession that.
Huh?
He's not in a possession of the landlord.
So therefore, if he is not in possession, then also you can grant it. The question is with, you see, therefore I put the question on my last order
Lordship.
of 27/11/2024. My goodness, 2 years back. 2 years back, I put an order that whether it would be in conflict with clause 1.14, wherein it says that you merely remaining in possession, you don't have a right. If you are in possession also, you don't have a right that you will get the settlement on that land. You may be given in some other land. If that be so, why you are not granting him? He says that he is in possession in 360.
Well,
So give him.
even in page 31, my lord, the ADC himself admits.
What is your instruction?
It's not very clear, Lordship.
It can't happen like this. We have it next week. This is math. This court sought for instruction on 27/11/2024 and till date. Proper instructions have not been placed before this court. List this matter on 29th of July 2026. Failure to provide the instruction as sought for by the order of this court dated 27/11/2024 shall be construed as this court may failure to provide the necessary instruction in terms with the order dated 27/11/2024. On the next day, this court shall be constrained to issue the appearance of the concerned person, the appearance of the concerned official responsible for providing the instruction. Perfect. Yes, what is this?
Matter
Can I
pertains to
pick up this matter? This has anything to do? Perfect matters is that Bhangagar man,
yes, yes.
huh?
Yes, Lord. Situated at Bhangagar.
This belongs to some serene, isn't it?
Sarin, yes,
Yes.
Vidyasagar sir.
This is the matter between here. By the way, Mr. Counsel, have you substituted the petitioner number 2 or not? He long died.
I'll have to take it.
Then I know this petitioner number 2. It is a very interesting history about this person concerned. He recently died. He died around 1.5 years back. He used to be my client once. He was the last person who came on the train from Pakistan to Delhi, Punjab. He came over, and he had he told me his experience what he had while traveling all the way. You know, and that was the last train which came during the partition time. It's a very interesting story. Very interesting. Anyways, do your due diligence.
Okay.
Yes. Yes, what is it?
Ma'am, please, Your Lordship. In this present petition, it was regarding to the allotment of shop to the petitioner, who are vegetable vendor of the Santar Bazaar, Karimganj.
Where? Samsar Bazaar. Reasonable vendors.
The market has been constructed and the petitioners as well other persons were at a meeting in the
municipality administration. And this matter probably become infractual, so there will be.
It is not affidavit that the petitioners have been granted allotment.
Not yet granted allotment. That
Then why do you say it to be infructuous? Or you are saying that it is going to become infructuous?
they have,
That is a submission which is never heard. That is
they
going to
have,
become.
they already the municipality have had a meeting with them. They are assured that the proper license will be given there.
Anyways, you want some instruction to please.
Yes,
When?
after 1 month.
Mr. Adhar, appearing on behalf of the Karimganj Municipal Board, submits that the matter that the Karimganj Municipal Board is trying to amicably resolve the dispute involved in the present proceeding. And in that regard, due steps have been taken. List this matter on 5th of August 2026 for an update. Yes, Mr. Upadhyay.
I want to do the case.
Huh?
Withdraw.
Withdraw. Anyway, the PV, Upadhyay, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Mr. J. Hendik appears on behalf of the respondent of our district administration. Taking into account the above, the petition stands still on withdrawal in term orders passed earlier. What is this?
Lordship, I am appearing on request of Mr. M. Saikya. Due to some serious medical condition, he is unable to appear before this court also.
Huh? What do you want?
Adjournment, Your Lordship.
Why?
Lordship, the learned
Ex
counsel
gratia for what?
or activist killing.
Huh?
Activist.
On account of the next of kin. Oh, extremist killing.
1 lakh had been already been paid in 2002, Lordship.
Now remaining
Now
3 lakhs.
remaining is my
2 lakhs. Remaining 2.
instruction.
Huh? We dispose it of. Same order.
Lordship.
I am extremist killing orders. Dispose it. In your favor.
Yes.
Extremist killing.
Page 20 is only you notice, Lordship. I issue page 21. 2G.
That without having any permission from administration, illegally you are carrying and running business from shop and store on the land. Farm. Then,
Our defense is that we are obeying the Gauhati land, not government road.
okay, you find it out. If it is other land to them,
Okay. Yeah, we have given the dark number, no, that dark numbers, Lordship, kindly see the page 21.
what Miyadi land?
We are
Which
not-
land you are in?
Lordship, our.
You must have taken a trade license.
Lordship, that all things are there, but actually, this business is for.
No, this is a government land and that too for the purpose of construction of PWD drain. You are no business of. I'm not going.
Lordship, you permission.
You have been issued notice, nothing there.
Construction was not constructed.
And how many dogs you are there? How many persons are here?
But that, there, Gauhati total land, dark number is 517. My lord, kindly tell the page.
One person, Prasanta Bol was 77 years old.
Yes.
What business does he have?
Well, he's the
He's the editor in chief of Mongol Batori.
weekly newspaper.
Huh?
Weekly newspaper.
And he is doing what business?
Nothing well, DTV center is there.
Huh?
For typing his newspaper. DTV center.
No, he is the editor in chief of Mongol Batori.
Yes, sir.
That is his business.
Yes. Sir.
And what is he doing in carrying on some shops and establishments?
Well, some shops, well, 3 or 4 rooms are there. One is he used for own purpose for typing the newspaper.
DTP center is there, other two rooms are rented out.
Well, it can be on government land.
No, not well at government level, but please 38 lordship may be paid.
This notice has been issued to many people.
Lordship, it was given by lot so many people. They are near
Yeah.
about 90, 87. But he's not there. Well, is whimsically well, this notice has been issued. What well, plan is there?
Okay. Don't remove him from any land.
From order that
You claim that you are in Dag number
57.
517 of Pata number 870
Lordsman.
at Mongoldoi town. What is this the schedule you have put?
Well, at page 30 here, there is well, daily permission, took permission for construction which is established my lordship.
Huh?
Page 38, madam. Page 38, annex 6, my lord. This was a site plan on which his establishment is constructed. Duly permitted by the municipality board of the Mongol. Well, whimsically passed. There is no.
No, don't worry. If you are in this land, they would not.
Does not change.
But if they are in other lands, they
Other
can.
than CBA occupied lordship, well, it can be.
Better over?
Yes, well, that or instruction, well,
Not instruction. Instruction not required. We pass that order. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Advocate appears for respondent number 1. Mr. MC Bhuya appears for respondent number 2 and 5. Respondent number 3 and 4.
3, 4 and
respectively.
6.
And 6.
Lot
And 6.
But it is not.
6 also, na? The present petition has been filed by the petitioner, challenging the notice dated 12/8/2021, whereby the petitioner have been issued a notice along with 86 other persons to vacate the land of the government land covered by Dag number 466, 473, 524, 4677. It is the specific case of the petitioner that the petitioner's land is in Dag number 517. 517 or
Yes, well, I want 7.
517 of KP Patta number 870 of village. Where village? Of town. Mongoldoi Hodor. Oblique Mongoldoi oblique Topai lot number 9. Isn't it? Where's your land?
Lordship, land page 31.
Oh, you people prepare your petition in such a manner, they don't know how where's your land. This patta also you you have not produced the patta properly. Yes, Mr. Henry, kindly see from page 29 if you can identify.
Lordship.
On top.
Page 31.
No, 29. 31. 31 is there.
Lordship.
When the Hukuma mote so and so mote dui kotha
Mutation.
No, I understand, but how do you express the land? I think
Lordship has page,
Advabandi for survey beneath. Huh?
34 lordship. Measuring that number so and so situated in Mogolrai town.
Mongoldoi town,
Hang on.
that could it be enough? It is the specific case of the petitioner that the petitioner is the owner of a plot of land at measuring 2 kathas covered by dag number 517 of kata number 870 situated at Mongoldo town, Tengabari.
Tengabari. Yes.
And as such, in the district of Darong. And as such, the petitioner ought not to have been issued the said notice dated 12/8/2021, inasmuch as the petitioner is not in possession of the land covered by dag numbers 466, 473, 524 oblique, 524 and 677 of Sopai Moza of Mongoldo town. This court have duly taken note of the documents which have been placed on record, wherein the petitioner claims only to be in claims ownership and possession over a plot of land at measuring 2 kathas covered by dag number 517 of KP Patta number 870. And the said land being the land belonging to the petitioner. The respondent authorities cannot evict the petitioner from the said patta land of the petitioner. On the other hand, it is also not in dispute that the petitioner claims no right over tag numbers 466, 473, 524, 677 of Sopai Moza within Nogao and Mongoldo town. Considering the above, this court therefore disposes of the instant petition, thereby directing the respondent authorities not to evict the petitioner from tag number 517 of KP Patta number 870 of no, not Sopaigao. Sopaigao is the other one. Of Mongoldo of Mongoldo town, Tengabari, in the district of Dorong. These observations, however, shall not, these directions of the observations shall not preclude the respondent authority to initiate and take steps in respect to the land so mentioned in the show cause notice in the notice dated 12/8/2021 in respect to dag numbers 466, 473, 524, 4677 under Sopai Moza within within Mongoldo town in the district of Darong. The petition stands disposed. Yes. Interim orders. No. Yes. What is this?
This is under NSEC 1994.
Huh?
They're telling the order in original on ground that is it service is exempted.
What they have challenged? Policy methods.
Is 92.
Along with the
Like a
penalty, man have exchanged on the ground the income was without affording opportunity to the provincial revenue personal. Right. But, he's being enjoying a stay.
It's like,
Where is he?
possibly he has some difficulty. Probably he was here in the court, but this plot has been entered into his house.
Who?
So produce thus.
Who entered?
Water Place
What?
order has been entered.
Raining outside.
Yes, sir. Here in the afternoon, lordship, from 12:30, there was a rain.
Hello. Okay, we think you got the records.
Lordship, I'll produce the record.
You only said that you will produce the records.
So, lordship, here, lordship, alternative remedy is there.
Understood. You catch your phone and take your phone outside. If you have any problem with this appearing in the court, you need to switch it off or put it in the silent mode. Does it look nice of a senior counsel? You say on 7/9/2022, he therefore seeks leave to produce the records before this court. Mr. Kyle further submits that the order under challenge is appealable and therefore is dismissed. And therefore, this court has no coercive actions. Okay. List this matter. None appears on behalf of the petitioner on call. Mr. S.C. Kyle appears. Standing counsel GST appears on behalf of the respondent number. All the respondents. Taking into account that there is an interim order. You're not filing an affidavit also.
We have not filed yet. May not be required.
Taking into account that there is an interim order which is operating, this court fixes this matter on 22nd of July 2026. The records pertaining to the passing of the order in original, the records pertaining to the impugned order dated 24/3/2022 be produced before this court. Interim order passed earlier shall continue. Instructions.
For last instruction, Rocky, it will be considered in the last meeting, resettlement meeting proposal. Thereafter, Rocky, it was not there. It was of 2024 instruction that it will be considered in the next SLDC meeting.
What?
So.
On 29/11/2024, the instructions so sought for by the order dated 3/10 have not been placed before this court. List the matter after 4 weeks. In the meantime, instruction be placed.
Received document that it will be placed before the next SLDC.
When?
It was 23/12/24. So thereafter, Rocky, what had happened?
Next week. The instant petition has been listed before this court. Almost after 1.5 years. However, the instructions which have been sought for have not been placed. Accordingly, list this matter again on 24th of July to 22nd or 24th of July 2026.
Okay, basically on 28. 28.
Why 28? Ask somebody else to appear on 24th of July 2026. On which date the respondent shall place the instructions, failing which this court shall have no other option but to seek the personal appearance of the person responsible for providing the instruction.
So you already we received the instruction that
Not the instruction of 2024 would not do.
logic it is after the order logic. That after the logic's order, it was received that it will be placed before the next SLDC meeting. Thereafter, logic what happened between 23/12/24 to today logic yet to.
So we have no. These are all matters coming after years.
Here also actually, as on the go also have no instruction whether he has got the relief or obstruction.
What relief?
But, there was some obstruction in the path of his shop whose license he was given. Not, he was given a license to operate a shop in the STC complex, Badarpur.
Where? Badarpur.
STC station complex, Badarpur. Here, some obstruction was put up by somebody. With regard to that, here filed multiple representation for STC to remove their obstruction. That was not removed.
Yes, what is your instruction? Well, I have asked for the expert to place the instructions, Milord. It's not coming. Next week, Milord, I'll come up with the appropriate resolutions. They have just one objection only, that he got a shop there in 2018 itself. Somebody has put up something obstructing the approach to his shop. So that was asked to remove. It was not removing. So that is why this resolution was filed. So Milord, in the meantime, it might have been removed. So therefore, we need to get that instruction. Milord, next week, Milord, I'm come up. Next week. If it is not,
The
removed, we'll remove it.
instructions as sought for is not yet been placed before this court. Mr. A. Somewhat the learning counsel appearing on behalf of the ASTC submits that you produce the instructions next week. Lists this matter on 22nd of July 2026, on which the instructions be placed as to whether there is any obstruction still remaining, and to provide an updated instruction.
Develop.
Because in the meantime, he may not be there also.
Because it's a 10-year operative.
These are
license.
10-year. UK does.
Lordship, in item 38, Lordship, as per your Lordship's previous order, the amount has been paid to the petitioner, Lordship.
Which one?
Item 38.
38. 38 is Ajit Kumar Nath.
Lordship.
We got the money. Earnest money, so and so. Yeah. But that day you went away. That is the way. I was looking for you. I could have passed that order, this type of order on that. Because there was a stay out. But I made some corrections also. I made some changes. Anyway. Mr. UK Das, the learned counsel appearing on behalf of the petitioner submits that the petitioner have received the entire amount as reflected in the order dated, as mentioned in the order dated 24/6/2026. And it therefore submits that the petitioner would not like to further pursue the incident with petition. Mr. So-and-so appears on behalf of the Forest Department and so-and-so appears for the what? 7. Appears for respondent number 7 and you appear for respondent.
Forest Department.
Forest Department. Taking into account the above, the writ petition therefore stands closed.
Lordship, item 39, Lordship, we have received the additional affidavit today about the breakdown of the price amount, Lordship. So we'll be paying that amount to your Lordship, 1 week time.
Where is the addition?
I have had my on
You filed it?
7th July. That is tagged by.
Oh,
pink.
give it. Somebody filed it on 7/7. He
My
also-
lord, I had. Is 145 million.
So this is the amount,
My
145.
lord.
Earnest money, 10%, so and so, you are going to pay.
Lordship, 1 week's time.
8 weeks now, order to go. A2, he about his to into order, so no, the order to make only physically. Have you sealed the communication dated? Yeah. What have you assailed here?
My lord, that is my lord, cancellation order, my lord.
What is the communication dated? 4/11/2000.
My lord, 411.
In respect to
411, 911. Lord.
411 and 911, Lord, sir. In
411,
respect of
2022 and 911, 2022 issued by respondent number 3.
my
Where issued?
Lord, sir.
Unprepared. We again adjourned the matter for another 6 months.
No, my lord. I'm sorry, my lord.
Now, what is wrong with both of you? This matter got adjourned on the last occasion because of your
That
inefficiency.
is, my lord.
And you are also, you are new counsel.
Lord,
How many years of practice you have?
Lord,
2 years. Go. Ask somebody else to come appear.
411.
Not done. You should have appeared.
411, 2022, my lord.
Huh?
On communication is 411.
This can't be done like this.
411, 2022, my lord. And another
Uh,
911. It is.
Your name to need. Don't put it. Get any forest council. I am not going to recommend. Get hold of another forest. Bring Mr. D. Goboy or anybody.
They are
No,
not in station. Out of-
okay. The matter could not be taken up today on account of the forest council, forest department. Itu agor to dispose of no. It has been sub, Mr. Enegel, equally, agote UK does not don't put a forest department. It dispose of it. The matter could not be taken. An affidavit has been filed, additional affidavit has been filed by the petitioner in pursuance to the order passed by this court on 24/6/2026. The said additional affidavit categorically mentions that the petitioner herein is willing to give up his claims made in the instant with petition subject to the respondent forest department refunding the amount of rupees 54,70,063, which is specifically mentioned, the details of which have been specifically mentioned at paragraph number 5 of the said affidavit. Taking into account that none has appeared on behalf of the forest department, this court is not in a position to take up the matter, obtain the necessary instructions. List this matter again on 17th of July 2026.
Wait, Your Lordships.
Yes.
Your Lordships had passed an order directing the bank to file an affidavit in compliance with the orders dated 7/8/2024, 17/9/2024, and 29/1/2025. Now, one affidavit has been filed by the bank, but the bank is narrating the entire facts and putting the entire blame on the petitioners, stating that the auction which had taken place was on as is, where is basis and as is, what is basis. At the time of the auction, it was portrayed by the bank that the possession is already with them. So if the possession is with them, the bank was supposed to give the possession of the property to the petitioners. The possession was not handed over to the petitioners. They have admitted it before this honorable court as well. Subsequently, the title suit got restored, because of which, due to the injunction order, again, the possession cannot be handed over. So in the instant writ petition, my only humble prayer is that the amount, the 55 lakhs rupees, which was paid to the bank as the auction money, that money should be returned along with interest, because the amount was paid way back in the year 2014. From 2014 till date, the money is lying with the bank. This as is, where is concept, or as is, what is concept will not apply in the instant case possession was with.
Who is appealing to the bank? Have you executed the sale deed?
No, Lordship.
Sell certificate was. Sell
Sale certificate, forget about that. We executed the sale deed.
in terms of lordship, I'm explaining it in terms of section 17(2), lordship. 12, Roman 12 and 89.
Huh?
In terms of section 17(2)(12) and 89(4) of the Registration Act, he becomes the title holder, lordship.
Where is the sale certificate?
Immediately after,
Under the Registration Act,
yes, lordship.
he becomes the owner
He becomes the owner.
of the land.
Land. No separate sell deed, nothing is required.
17.
17(2), Roman 12. And along with section 89(4) of the registry.
You are not by a civil or revenue officer. Are you a civil or revenue? You don't make the sale in terms of bids. You make the sale in terms of the income tax rules. You have an income tax rules. It is on the basis of that you do it. When the certificate of sale is being issued, the income tax
Is by
it is being
public.
done on that basis. What about the possession? And there was some suit also.
Some sort of.
And you sold the property with encumbrance.
So it is as it were his basis, lordship. As it were his basis, lordship. He has agreed to.
As is where is receipt? It can't be like that. Let us see how you could have sold it like that. Affidavit in opposition filed by respond number
1 and 2.
As is there is basis stand was never taken in the affidavit in opposition. This has been taken for the first time in the additional affidavit which has been filed recently.
where
This additional affidavit is of 8 May 2026, page number. It starts at page number 165.
where is your auction notice?
Auction notice. Lordship.
Where is your auction notice?
Postponed notice is there, Lordship, at page 33. 33 of the writ petition.
Page
33. 33.
33.
This
And
is the notice by which
scheduled
the
to be
auction
held
was.
on so and so, being postponed due to unaware. Is now scheduled to be held on so and so. Other terms of the auction notice. Where the auction notice?
Lordship, I do not have a copy of that.
That is the where one can show that there is a as is where is basis. Here, possession notice. Whereas so and so, Nago Kumar does to repay the amount of demand minus need to repay the amount of hereby. This is what will happen. Application and then application.
Let me just point out one aspect, Lordship.
Where is it that as is where is basis?
That is just a statement made in the additional affidavit.
Which edition?
Yes, Lordship. I'm saying the page
This
number.
Akhtas Mir Ali.
It is at page 170.
I think you have to provide info documentation.
Auction notice is at page 197. 197.
Participation in the industrial bank so and so restricted the deposit payment. Where is this very?
Clause 8.
Huh?
Clause 8.
What?
The property is being sold in as is where is and as is what is basis and subject to the conditions prescribed in the Securitization Act 2002. This auction notice is 30th-9/2014.
We have it on another day. Which will require some hearing on there. Let's have it on 4th of August. For final disposal. We will require to, this court may be placed with this aspect as to as is varies basis and what is as
The interpretation of as is where is and as is what is.
as is what is. As is what is basis. What is basis, as is where is basis is.
Yes, Lordship, the place where it is.
As is what is basis we need to discuss by the time. The materials on record show that the pleadings are complete. This court is also of the opinion that the matter, the instant repetition requires an early disposal. Accordingly, list this matter on 6th of August 2026 for final disposal. Liberty given to both the parties to mention the matter for pleading.
Yep.
Okay, done.
Read this.
I'm telling the order in original on the ground, my lord, that no circuit was served in the petitioner, my lord.
What?
I'm telling you the order in original, my lord, at page 111, my lord.
So you say that 7/10/2021 order, you have not received it?
So course notice we have not received it, my lord. Actually, there were two focus proceeding. One focus we received, it was in 2020. We submitted our reply. They have not decided yet. Another focus was issued that we have not received. We received only order, my lord. After receiving the order, we immediately made a representation saying that we have not received any order, my lord. Focus. We have to be approached the honorable court. Huh? We have not received any so notice with regard to the order in original, which was passed on 24/3/2023, madam.
Order original passed under what? 73 or 74?
So my service tax 73, madam. Service tax matter.
Service tax.
Before that, we have received another so notice for prior financial year. That is, we received, we have submitted our reply. That has not, they have not decided yet, my lord. We have no intention to avoid any notice, my lord. We received one notice, we replied, my lord.
So you did not receive the show cause notice dated 7/10/2021,
That we have not received, my lord.
and you were not intimated about the personal
No,
hearing.
my lord, we have not received, my lord. Because we have, if we had, we have any intention to avoid, my lord, we would not have briefed.
Yes, this matter on 16th July 2026 at 2 p.m. for final
My
disposal.
lord, in
In term of the
17,
past
16,
year, shall
16, I
continue
have some difficulty, my lord. 16, I have some difficulty. 17 or any date apart from 16, my lord.
Any
Some-
date thereafter, interim order shall not continue. Okay, we have it on 17, interim order to continue till 16, okay?
No, my lord, then. Much obliged.
Mr. Matter. Mr. Matter again on 12th of August 2006.
We are filing our appeal by tomorrow.
Hmm?
Tomorrow we are. There's nothing. Like.
You're filing it tomorrow. Mr. S.S. Roy, the learned counsel appearing on behalf of the state, submits that the affidavit would be filed on behalf of the state by on 14th of July 2026. The petition lists the matter on 24th of July 2026. Liberty given to the petitioner to file reply thereagainst on or before the next.
What's the matter regarding compensation of a dhaba which was run by me and my late husband? What has happened? My husband also has married respondent number 4. So on the day of inspection, the authorities give all the compensation to respondent number 4. The issue in the case relates to that.
Why are you here? You have no business to be here.
I filed representation before the authorities.
No,
also.
you have to go on the 3H4.
Let's have a.
Yes. This is not the place. Okay. We do one thing. We finish it off on the next date. Okay, tomorrow at 2. Tomorrow. Okay. With the matter tomorrow at 2 for final discussion. This matter on 14th of August 2026.
My lord, in this matter, when respondent number 2 has filed their affidavit, my lord, we need some time to file our rejoinder. Matter regarding acquisition of land, my lord.
Respondent number two has filed affidavit.
Reply. You want to file a reply?
My lord. Sometime needed, my lord.
Huh?
Three weeks time, my lord. 3 weeks time, I believe.
Counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply to the affidavit filed by respondent number 2. List this matter again on 31st of July 2026. In the meantime, the petitioner is granted the liberty to file reply by 29th of July 2026. Interim order passed earlier shall continue in the next day.
Hello.
Yes.
My lord, petition is the local pilot driver. His account has been freezed by on the basis of complaint from Aja police station. His salary account. He cannot both debit and credit account has been freezed. But affidavit filed by the Aja police state that we have not direct anyone to freeze the account. Because if you lordship go through that affidavit filed by the bank, Aja police.
I have already filed my affidavit in opposition, lordship. My lord, before taking up the pleadings, he himself, the writ petitioner himself admitted in para number 5 of his writ petition that he is indulging in online money game, lordship.
Money?
Money game, lordship.
Then?
And it is prohibited under the Promotion and Regulation of Online Gaming Act 2025, lordship. Section 5 and 7 prohibits such game, lordship.
Who are you?
He's I'm the bank, lordship.
So what are you saying about all these things?
No,
It
my
is for
lord,
the police to say that.
Yes, lordship.
Let the police say all these things.
Yes.
My question is, here only 3 lakhs is the 3,000 is the amount which has been reflected.
Yes,
If
lordship.
that amount and remain to allow him to defreeze the account.
Yeah. If you lordship that, then
Defreezing order to the.
obliged, lordship.